One day, please. No.
I mentioned this matter yesterday.
Extremely sorry.
My lord, your lordship just, my lord, asked me, my lord, to know the, my lord, the
Follow the
date
list.
of financial bit.
To be mentioned, item number 1 for correction.
I was the petitioner, lordship, my lord. Instead of 2021, that should be 2023, my lord.
The number.
My
Last paragraph, my lord. The petition number.
initially number has been given 2021, your lordship, my lord.
The WPA number.
On the yes, my lord. On the first page, my lord.
As a very.
That should be 2023, lord.
In the order dated July 24, 2023, comma, the writ petition has erroneously been mentioned as WPA 12921 of 2021 in two places, comma, particularly in the cause title and the last paragraph of page 5 thereof, comma, as the full stop. The actual number of the writ petition is WPA 12921 of 2023, full stop. Let the said order be deemed to stand corrected accordingly by reading 2021 as 2023, full stop. This order be treated to be a part of the said order. Sorry, yes. Thank you.
Extension of interim order, item 2.
On my application for extension of
Not
But I am-
matters, yes.
Well, I am opposing this application as because non-implementation of policy decision of ACDCL regarding the safety measure taken for the contractual employee lordship. My lord, on 12th December, my lord passed an order restraining us. Thereafter, time to time, it is being extended, lordship. If your lordship so desires to extend it for a limited period, because we are suffering an interim order, lordship,
The interim order is extended till
challenging the policy decision.
August 31, 2023, full stop. Learned Council for the respondents opposes said extension on the ground that the writ petition has been taken out against a policy decision. Full stop. Next para, be that as it may, comma, there is no reason to deviate from the original order, original ad interim order granted. Full stop. However, comma, in view of the point taken by the respondents, let the matter be listed on August 22, 2023, fairly at the top of the list for hearing. Thanks. 22nd August, fairly at the top of the list for hearing. কতদিন পর্যন্ত দিলাম? August 31 পর্যন্ত. Can 3 of 2023 is disposed of accordingly with liberty to the petitioner for pray for further extension if need be, comma, on the basis of the main writ petition.
Lordship.
This is already part heard, my lord.
Yes, it is part heard. It will appear as part heard.
Lordship.
Top item, item 3.
Lordship, on behalf of the petitioner, I'm paying for a day's accommodation, Lordship. My
Mind
Paying for a?
only a day's accommodation, Lordship.
We
For
are
a day's
appearing
accommodation.
for the-
On
Is it
your pair,
appearing?
it is appearing at the top.
Yes, Lordship. There has been inadvertently there was a miscalculation in the of the day where he would be available.
An adjournment is sought for the petitioners. Full stop. The matter was fixed at the top at the behest of the petitioners. Full stop. In view of such adjournment, comma, let the matter stand adjourned till the monthly list of August 20,
Lordship,
monthly list of September 2020.
Lordship, there was an
Sorry, no.
Lordship, there was a miscalculation in the Lordship. Kindly
Item 4.
Yes, 4. Yes, Mr. Lairi, what is the matter?
Well, this is a case where the son has filed an application for appointment of himself as a guardian of the father who is in a comatose stage. Well, as on date, there is no law in the country which covers the guardianship of a person in a comatose state, my lord. My lord, may I place the
Is the,
Item 4? Yes.
yes. Anyway,
may I, my lord, hand over the laws, my lord, first.
please take your seats, both of you. Yes.
But may I first, my lord,
Please do. I
The
think that will be
first-
easier.
the first law is the Guardians and Wards
There
Act.
is no doubt on the comatose stage, I think.
No,
So on the law.
on the law, my lord. My lord, first the Guardians and Wards Act.
Yes, yes. You are Hindus.
We are Hindu. My lord, Guardians and Wards Act, my lord. Section 6 deals with minors. Oh, my section 7 states that where the court is satisfied for a welfare of a minor, that the order has been passed.
This does not apply.
So, my lord, then there is, my lord, section 8 persons who can apply.
So that is also circumscribed by.
That is my lord there. Now the next law is, my lord, this has got two books, my lord. This book has got two legislations.
What is the age of the father? Just,
Well, he is
although
about-
that's not relevant here, but
No.
even then,
He's about 70.
around 7. And you are,
And I am,
just see the affidavit.
that's this. I am 34.
The son himself has preferred this.
Son has preferred
Affirmed the.
affirmed the affidavit, and the mother and the two daughters have given affidavit which have been annexed.
Excellent. Very well. Yes.
Wonderful.
Yes. The next.
Now, my lord, right to person with Disabilities Act, my lord, may I place section 2S?
Give me half a minute.
Well, I have flagged them, my lord, for.
Yes. Yes. Obviously.
My 2S says persons with disability means a person with long-term physical, mental, intellectual or sensory impairment, which in interaction with the barriers and hinders with full effective participation of society. So, my lord, physical, mental, intellectual and sensory.
So this is the closest.
My lord, yes. And now section 14 of this act
Mhm.
states about provision for guardianship. Notwithstanding anything in the law in force, the date of commencement of the district court or the designated authority, state government, person with disability. My lord, here it's a person with disability. Now, this person does not come under the person with disability.
Why do you say that?
My person with disability, my lord, again the definition,
Yes. let us come back.
long-term physical, mental, intellectual, sensory impairment.
Comatose stage is
Neither.
why not sensory impairment?
A sensory
Mental,
impairment.
intellectual, or sensory impairment. Comatose state is that.
No, my lord, I will again come to the certain judgments of different high courts in this
All
regard, my lord, where it has been held.
So
Well,
it's not a mental or intellectual or sensory
No,
impairment.
no.
What is the actual state of a comatose condition?
Comatose condition is a person who is alive
Yes, obviously.
but he cannot move, he cannot.
So Lahiri, have you done a clinical research on this?
Yes.
Will you satisfy me on that also?
Well, the judgment also says that, and
Let-
Anita Schonberg is clear on what is comatose.
Will be on that.
Well, I'll place Anita Schonberg.
Let us proceed on. Yes.
Now, my lord, kindly then take the Mental Health Care Act, my lord. Well, Mental Health Care Act, section 2S says about mental illness.
2S is a favorite.
2S is mental illness. Same,
Favorite
similar-
of the legislation.
Similar act, my lord. And section 14 again talks about 2S.
Yes.
Means a substantial disordered thinking, mood, perception, orientation, memory with gross empires of judgments, behavior, capacity to recognize reality or ability to meet ordinary demands of life, mental conditions associated with abuse of alcohol, drugs, but does not include mental retardation, which is a condition and arrested of compliance of development of mind and specially characteristic by intelligence. Now, my lord, section 14 here again speaks of appointment of a guardian, of nominated representative. We are not a guardian, but a nominated. Well, under the old act, it used to be the court. Now it is before the department, before the board, not before the court. Under the Mental Health Act, it was always before the district judge. Now it is before the board. It is appointment of a nominated representative. It has to be for the person who suffers from mental illness. And the last of
You
the
say this is also not
no,
applicable.
not applicable.
Mental illness in the common sense, no, but does it not come within this?
No.
I mean,
Well, I'll refer to the judgment of command.
very
Next-
close, but
Well,
yes.
very close one.
Hmm.
The next is, my lord, National Trust for Welfare of Persons. That is in the book with right to disabilities. The next two flags, my lord. All right. National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities.
Hey, auditor. No.
My lord can keep this. My lord can keep these books.
No, judges have a tendency of forgetting
Yeah,
to
yeah.
return.
No. My lord have not to return these books.
I don't generalize judges, but I do have.
My lord don't
I
return
may
these
not return, so let us have a book from
But
from
my
our
lord, he
resources.
just gave this
No,
book, my
he'll
lord.
just take down. They are they can professional right of persons with disabilities.
But here,
Time being, Mr. Lahiri, I'll have to keep this book because I.
my lord has to keep these
Very
books as
well,
of now.
Yes, please continue.
But section A is autism 2A. 2A
This
defines,
is not autism.
no, the autism cerebral palsy is 2C, 2G is mental retardation, and 2H is multiple disabilities. 2 or more disabilities defined in I of section 2, which will then notify. And again, my lord,
This probably does not come in.
section 14 is again appointment of guardianship.
This does not come in at all.
But these are the 4 legislations where guardian can be appointed for a person under the present laws, my lord.
Closest are the other two apparently.
Madam.
The 2016 Act and this.
Now, the only thing, my lord, I would not be out of place to mention here because one of the judgments refers to it.
Yes.
My lord, though it has been negated,
Mhm.
my lord, may I refer to order 32A?
Yes. Relevant. Very relevant.
Relevant, my lord. One of the judgments refers to it, but
Very relevant.
negates, my lord.
Obviously, but CPC na.
Order 32A2C.
Yes.
This can be the closest, my lord, because what it says is particular the proceedings, rule 1 provisions of order will apply to the suits or proceedings concerning the family, namely a suit or proceedings in relation to the guardianship of a person in custody or minor or other member of family under a disability. So this can, my lord, come closest where I could have otherwise gone, otherwise
Disability is general.
well, yeah. And my lord, I am involving the parents patriarch jurisdiction of this honorable court because there is no law, my lord. My lord, may I now place several high courts.
This is not, in a sense, it is not adversarial.
No, this is not an advisor.
Not, naturally, disability has not been defined in civil procedure.
No.
How can it be?
Nothing. But when the first of the judgments started at Kerala, well, may I refer?
Please.
At a copy the other side.
You are for the state. You are for the state.
Union. So union and state both I have served and both are appearing. I will serve this judgment. But may I place? This is the first judgment.
Give the citations so that they can at least.
No, I will. This is because these are all SEC
You have to
online.
give to both the union.
Both I will give. I have made copies.
Otherwise, there will be a civil war.
No, I have made copies. I know because that's why I made copies. I will hand over the entire bunch. But this is 2019 SEC online Kerala 739. Shobha Gopalakrishnan was the state of Kerala. Well, straight away takes paragraph 2. The victim lying in a comatose stage is having properties in small bank deposits, but the petitioners are not in a position to deal with the same because of legal hurdles. They have already incurred huge expenses as borrowed from different corners in connection to the treatment. Having exhausted all financial resources, they are in a state of despair, isolation and abandonment because undergoing agony, stress, depression on account of plight of their near and dear one dying in a permanent vegetative state and coma. The petitioners are constrained to approach this court for appointing the named petitioner. Here the wife came as of the patient in the comatose state as a guardian, contending that no legislation in India does provide for the appointment of a guardian of a person in comatose state, unlike legislation for appointment of guardian for minors and person with other disabilities and like mental retardation. But now,
I'm sorry, before proceeding further, what is the reason for your your father's comatose stage?
well, my father actually went to Hyderabad for attending a family function. There he fell. He was actually, I think, what is said in the petition is he has suffered a massive stroke, and then he could not recover from the stroke.
Mrs. Lahiri, please ask your learned junior to just give me the paragraph numbers regarding his falling into a comatose stage. Paragraph numbers of the writ petition and the relevant annexures page numbers. Just write on ask your learned junior to write on a slip of paper and hand over so that I can have a copy of that. Let us continue with this. Yes.
Now, my lord, kindly takes paragraph 4. According to the petitions, neither the Guardians and Wards Act 1890 The National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation and Multiple Disabilities Act 1999, hereinafter referred to as National Trust Act, Mental Health Act 87, subsequently Mental Health Care Act 2017, nor the Rights of Persons with Disabilities Act does come to the rescue of the petitioners insofar as the appointment of a as the appointment of guardian of a person lying in a comatose stage in concern. But that's why I placed the 4 laws, my lord. Now, my lord kindly takes thereafter paragraph 15. As mentioned already, there has been no dispute as to the plight of the patients, victim concerned who are living in a comatose stage as prisoners of their own body, unable to respond to any stimuli, and the world around. The entire family is affected because of the agony, stress, depression, finding the dearest one in a permanent vegetative state and coma, leaving themselves in an utter state of despair and isolation environment. They have borrowed amounts from different corners and finding no other alternative to tap the exhausted financial resources, bleak future. I will not read all these.
No need, no need.
Now, 16. In the above, it will be worthwhile to a survey of various legislations to see whether any of such statutes does contain a provision for appointment of guardian in comatose stage.
17 rules out guardians and wards are rightly.
Then, my lord, it rules out all the acts and the sections which I have quoted, my lord. Mental Health Act 87 is not there anymore, my lord. It's replaced by Mental Health Care Act. Then that is paragraph 20, Mental Health Care Act. Now, my lord, 18, 19, now, my lord, nominated representative, then it goes on to section 2S of Mental Health Care Act in paragraph 23. It is quite evident from the definition 24 that substantial disorder which does not include mental retardation. Determination of mental illness is dealt with under section 3(1) of the Act. Subsection 2 of section 3 is no person authority shall classify a person with mental illness except for the purpose directly related to the treatment of mental illness in other matters covered as by the Act or any law in the time in force. Subsection 5 of section 3 says that determination of person's mental illness shall only be implied taken by means of is of unsound mind, unless it has been declared by such competent court. The term unsound mind and competent court, I will not place that. Next section, paragraph 26. Paragraph 26 treats the National Trust Act. Now here, my lord, 8 says about multiple disabilities. And it refers to disability opportunities of Full Protection Act of 95, which has been, my lord, now replaced by the mental, by the, my lord, right to Disabilities Act. But the definitions are there. My lord, disability means what are the disabilities have been said. Now, my lord, section 2J of the Trust Act says about 2J, then persons with disability, what are there? The definitions have been said. And then the relevant to make 2O of the National Trust Act. 2O means several disability, which means 80% or more of one or more multiple disabilities. From the above, it's clear to identify a person having multiple disability, exhibiting 2 or more disability. Right of full person, a person with disability, what are they? My lord, they have said. Now, right to person with disabilities act, my lord, now it is dealt with section 13. And then it says that admittedly persons with disabilities act equal opportunities having no more been repealed by section 102, where the comprehensive new law has come in, no similar provision defining disability as under section 2I of the PWD Act anywhere in the RPWD Act of 2016. Later enactment, particularly under section 2ZC of the RPWD Act, defines special disability as in the schedule. Special disability means physical, intellectual, mental, and disabilities what are there. Parkinson disease, blood sugar, hemophilia, thalassemia, sickle cell disease. Now, section paragraph 36 is important.
Recently, there was a reporting in the internet in those websites. After 5 years, a young boy came back after a comatose stage. I mean, he said that every moment I could understand what was happening. So that's very, uncanny in a sense. You have to be very careful on that also.
It can be one.
In some cases, at least.
In some cases, can be. But my lord, it's a now about 7 years. 2016.
5 years is also unnatural.
But sometimes it happens.
Sometimes. Up to 9 years, they say that's the last limit, right. The outer limit.
But he fell ill in 2016, so we are now.
No, 9 years is an outer.
Limit.
Yes.
36. From the above, it is clearly discernible that a person in a comatose state is not a person who is having any two or more disabilities continuing of multiple disabilities to the requisite extent as mentioned in the statute, so as to come under the purview of National Trust Act. In other words, so as to bring within the purview of National Trust Act to be dealt with by a local level committee constituted under Section 13 and other relevant provisions of said act under Section 2H. Such other provisions of the relevant statutes may require amendment to the requisite extent as it stand in the instant case, and that a person who is in a comatose state does not come under the purview of the National Trust Act. Then the verdict, then there is a judgment which is referred to, which is the earlier judgment. Now 38. Now 38 is important because Aruna Schonberg has been
Distinguishes also
quoted. No,
between.
quoted.
Hmm.
What is coma? But I have got Aruna Schonberg, my lord.
Yes, we'll record that. Distinguishes in brain death, vegetative, and
Yes.
coma, the three
My lord,
degrees.
Right, Aruna Schonberg today. Motata, Aruna Schonberg. Motata. Because sometimes quotations may, well, I've got the judgment. my lord.
Yes, that
It
is
is
better.
reported in 2011, 4 Supreme Court cases, 454. My lord. Here, paragraph 12 at page 477. But placitum H says about brain death. And then, my lord, next page, placitum B says about coma. But here coma is defined, my lord. Patients in coma have multiple failures of arousal system with no spontaneous eye opening and are unable to be awakened by application of vigorous sensory stimulation.
The doctors have classified your father as a comatose person.
But it
Coma.
has been said to be he is a comatose patient.
Comatose word has been used. Just check up that.
I have,
also. Please check up
no,
that, please.
I have not seen any, but he was
That's the
other
closest
medical,
expression
other
used.
medical terms have been used. But
So this is a classwork for a learned junior.
I understand. But I would submit after
Just the terms used, the closest
after
terms.
I place the judgments, I will place what I want. as a-
Definitely you will, but let him do
I
the
will.
classwork in the meantime.
So, my lord, this is a comatose stage under which has been referred to in, my lord, this judgment.
Yes.
The entire paragraph has been quoted about what is brain death, what is coma, and what is vegetative stage. My lord.
Are you coming back to the
The Gopal Krishnan judgment.
wait,
So, my lord, I have referred to paragraph 12 of that judgment, my lord.
right?
And, my lord, then paragraph 40. 40 deals with right of persons with disabilities act. Here minus 2S is quoted. And it says that interest of the patient in comatose state, particularly in reference to urgent need to provide treatment support beside immediate requirement of close relatives to raise funds who take care of the children cannot be ignored and compromised. He justifies invocation of power under 226 of the Constitution of India. Now, my lord, kindly takes next paragraph 42. Considering the role of the court under jurisdiction of Article 226 of the Constitution springs up, there is no remedy provided under any statute to persons like parents in comatose state. It is something like parents patria. Parents patria jurisdiction, a reference of verdict of Northam Man versus Bennett London Council is also relevant. Such cases often said are reference to be drawn in Surjit Singh Karla versus Union of India, explaining the principle of causa omnissus is also brought into notice of the court to the effect that if the accident omission, the court may supply fill up gap. This court, however, does not find appropriate to rewrite the provision as within the exclusive domain of the parliament. This mode, the relevant statutes like Mental Health Act, PWD Act came into repeal on introduction of new legislations of 2017 and 2016. In conformity with the mandate of Union Convention, this court does not say anything whether amendment is necessary so as to the acts with reference. It is for the government to consider the appropriate in this regard. It is never the court to encroach upon forbidden field. This court, this goes into what then it says that comatose state is not covered by any of the statutes as discussed above. For appointment of guardian, the petitioner is justified in approaching this court to invoke the power under 226 of the Constitution of India. But then, what is important is, my lord, at paragraph 43,
এটাতে অন্যটা নেই। আমি বললাম না তোমাকে যে প্রফেশনাল একটা আনাতে, ওদের বলো কিনে আনাতে। প্রফেশনাল একটা, তার কারণ আছে একটা বলেছি। আর একটা অ্যাক্টুতে আছে। সেই একটাতে আছে কিনা দেখে না, তুমি মিলিয়ে দেখে নাও।
on paragraph 43, the court lays down a guideline. The guideline, my lord, will
Still
look
guidelines.
into the guideline. But my lord, then paragraph 46, the person for whom the application was made on behalf of Shobha Gopal Krishnan died during the procedure. So no order was passed, but the next writ petition is WPC number 3726, which were heard together. Their guardian was appointed. Following this, my lord, next judgment. Uma. What is it? Next judgment I will refer to is 2020 SCC online, Allahabad 777, Uma Mittal and others versus Union of India. There, my lord, at first paragraph, they generally quote the prayers, the style of Allahabad High Court. Issue a writ or direction in nature of mandamus appointing petitioner, namely Uma Mittal, she wife of someone, guardian to her husband to protect the interest, administer bank account, investment, proprietary business, etc. in the event necessary to sell immovable property standing on the name of her husband to proceed toward medical expense of her husband and family. This is the prayer which is state up. Well, straight comes to paragraph 12. Well, I will not trouble, my lord. Again, all the acts has been stated.
Something has been added probably also.
Because Indian Lunacy Act is repealed. Then, my lord,
If the persons with disabilities equal opportunity,
is also repealed.
that is also repealed. All
These are all repealed.
It is
Now, 4
forgotten.
acts are there, my lord. So, my lord, thereafter the discussion is at paragraph 18. Here, my lord, Shobha's the last paragraph where all those paragraphs have been quoted.
Yes.
Now, my lord, important is here is paragraph 22, where, my lord, Charan Lal Sahu is quoted, which invokes, my lord, parents, which really deals with what is the parents patria jurisdiction. This is the Bhopal custody judgment, my lord.
Charan Lal Sahu is that.
Yes.
Yes.
I have got a copy of Charan Lal Sahu. But Charan Lal Sahu is reported in 1991 Supreme Court cases 613. Important paragraphs are paragraph 35, 36.
So should I look into Charan Lal Sahu or?
No,
Fair.
35 is quoted. Well, important kindly
I
take
think
a
that
note.
will be easier. Yes.
Well, paragraph 35.
Right.
Paragraph 35 is at page 647.
So I'll take up Charan Lal Sahu.
My lord. Here, my lord, parents patria has been, what is parents? My lord, parents patria, my lord, if my lord is with me on parents patria, this gives the first judgment on parents patria is Charan Lal Sahu, which is at paragraph 35, 36. The 36 is much more important. Therefore, conceptually, from the jurisprudence point of view, especially in the background of preamble of constitutional mandate of directive preserve, it is possible for central government to take over claims of victims. These are on victims, my lord. But 35 lays down the law what is parents patria. And my lord, the two others are 63 and 100.
Well, I'll look into it.
And 100 says about one. Now, my lord, it comes back to the judgment of Uma Mittal, where they have involved parents patria.
Shobha guidelines have been incorporated. here
Incorporate,
also.
my lord. And then, my lord, paragraph 26. Well, 26. In our opinion, present case, court cannot shrug off responsibility in distress call given by a thinking family for a person lying in comatose state for the past year and a half. The dominant factor, after all, not enforcing a right guaranteed under warring parties under 226, but a protection of the rights of a human being lying in a comatose stage under Article 221, under 21 of the Constitution. The court under 26 pass order give directions for necessary subserving end of justice to protect the person who are lying in a vegetative state. Under this court under Article 226 of the Constitution is the ultimate guardian of a person who is lying in a comatose vegetative state and may provide adequate relief for appointment. But then Shobha is quoted and the norms are being quoted in paragraph 28. Now, why I have said I will come back, my lord, well, here, my lord, you will see paragraph 30. Having gone through the medical examination report annexed to the sought counter affidavit, where a medical board constituted by the persons of the direction of this honorable court, I will take a cue from that and I'll make my submissions. And the government's whatever, my lord, then they appoint the guardian. But then there are my lord, 33 onwards.
The restrictions.
And it has said that 133 petitioners are under incur expense of the family welfare of married daughters. All these, what are the parameters have been given in section paragraph 33. And 35 will not sell an encumber without the permission
I
of the
think we said,
registrar.
Lahiri, I don't know whether that has been incorporated here. A time-to-time report from a body would be welcome, I suppose.
My lord.
A time-to-time report, feedback being given to anybody constituted of some authority would
My
be
lord,
welcome, I
Let
suppose.
me place the judgments in my
Give a protection to that, to the person who is
There is
involved.
no law. My lord. Court has to. My lord, I am seeking for an appointment of a guardian of the person and property of the person.
That has to be put, restricted by rider, that you will be giving reports.
Yes.
Suppose in 3 months or 2
My lord,
months,
my lord, that is
so that it is not cumbersome.
Yes.
But all the same, it's a protection of the right.
Protection of the person to the
Yeah,
registrar, or my lord will see the guidelines and then my lord will pass an order. But my lord, first I am taking the cue from this. My lord has to be satisfied that this person is in a comatose stage.
That is true. That is
So my lord has to independently see. So my lord, I will beseech my lord to
that misaligned, probably a medical board can only decide.
yes, and that interim order
That has to be there.
that has to be there, because before passing any order, my lord, I will beseech my lord
Oh,
to
you say that, yes.
and the report should come to my lord to be my lord has to be satisfied that the person is in comatose stage.
Very Here, that was not done.
Yes, here that was done. That's
Yeah,
why
that was
paragraph
done.
33. According to the accepting the medical report at SKM submitted by the medical board. I would not say my statement is a gospel truth in this, because
Get your point.
I have to be.
No, obviously you're trying to help your father.
Now, next judgment. What different high courts I am showing, my lord, is Vandana Tyagi versus Government of National Capital Delhi. This is 2020 SCC Online Delhi 32, paragraph 56 to 68.
Has Justice Shagdar added anything?
Cannot be added, my lord. These are all again those sections.
Comprehensive, very comprehensive.
Those sections have been quoted. And paragraph 68, a careful perusal of these definitions would show that a person who is in comatose stage is not covered.
This is paragraph
68. And then, my lord.
So I'll quote all these judgments and then give my judgment. So it will be thicker and thicker as
No,
it goes.
but I'm just giving that different, because there is
No,
no
Mr.
judgment
Rahid,
from
obvious.
this court.
You are
No-
doing your duty.
But there is no judgment from this court, so I have to place judgments from
You
different.
have to. Absolutely. Right.
And there is no judgment from Supreme Court. So,
So anything was added or modified in the guidelines?
no,
By
nothing,
his-
nothing. Same guidelines as Shobha was quoted in 75.
Great.
80 is important.
Yes.
The Department of Social Welfare GNCD to ensure public officials or officials equivalent rank to each district Department of Social Welfare oversight mechanism to close. These are the general guidelines. But here it was this case was an SBI account was not being allowed to be. So paragraph 77. Insofar as the present petition, the prayer made is same is allowed. The petitioner is appointed a guardian where the PPF account bearing number so and so maintained by the deceased father so and so. Upon fulfillment of requisite formalities, SBI will transferred the sort amount of PPF joint maintained by the petitioner Saroj Sharma with the HDFC Bank. So it was just because of that thing. 77 to 78, 56 to 68, and then 77 and 78. where the next judgment is
In paragraph 80, that social welfare that rider was put in,
that rider
that
was
safeguard,
that's it.
that he will visit and
Yes, yes.
give a
The next
time to
judgment,
time. Yes, yes.
the next judgment is, my lord, 2020 SCC online Bombay 880 Rajni Hariom. About the first time civil procedure code was taken into consideration.
But 32A does not give that does not shed much light because it's disability, which has again to be construed in the context of the statutes.
Now, my lord, paragraph 2 is wife of a husband is in comatose vegetative state, no signs of prospect of revival. Besides husband, petitioner has 2 sons, whom minor and dependent mother-in-law, who is mounting to medical bills, household expenses, have hardly income of her own. Petitioner helpless, turned into court into jurisdiction. My lord, then comes paragraph 17. Refers to all the judgments, my lord, passed by different high courts. And then, my lord, paragraph 30 and 31 deals with Aruna Shonbag, where what is coma has been stated. And then 33 states about the laws. Now 34 states about civil procedure code. At 36, however, instead of filing a suit under civil procedure code, petitioner has invoked jurisdiction for this court under Article 226. Before moving into Article 226, petitioner seeks guardian. Needs to be elaborated, discussed a little more in detail. Present case, then it goes to Hindu law, my lord. And then, my lord, 42. This brings us to the crucial issue of relief that may be granted to the petitioner invoking our writ jurisdiction under Article 226 of the Constitution. As we have already discussed, ideally a suit under so-and-so ought to have been filed, but though admittedly there is no statutory provision governing the field, leading to appointment of a guardian lying in a comatose stage. Reverting to Aruna Shonbag, then Shobha is referred to in paragraph 45. Vandana Tyagi is referred in paragraph 46. Uma Mittal, my lord, all judgments I have given, my lord. 51. At this stage, we may remind ourselves that the width and plenitude of the powers of high courts under 226 of the Constitution under clause 1, every high court within jurisdiction. Then it goes on what is the power of 226. And 54 from the clearly deducible that when a high court exercises jurisdiction under Article 226, it is done to cause justice. To provide justice, these are ex debicio justice is reason dita of the courts. The Latin expression justice means the debt to justice on account of justice. Well, the doctrine of execution well established, required no further elaboration. In addition to Article 226, power traceable to 151 and 482. Thus, having regard, my lord, 57, we are of the view that relief sought by the petitioner are reasonable and may be granted considering peculiar facts and circumstances of the case. However, to ensure the court return spirit, the essentials should come to a monitoring facilities. And then, my lord, 58 says about what kind of. Kindly takes paragraph 2 of this, the 58. All authorities shall accept her status as such.
Paragraph
58(2). This first judgment which says that this appointment will be in rem.
Yes, this has to be in rem.
Has to be.
Has to be in rem.
Prior to it, there is no guardianship is guardianship in rem. But till now, nobody has said about appointment of a guardian of person and property, which is the concept of Guardians and Wards Act. It all deals with property, not in person. But the next judgment, the Kerala High Court says appointment of a guardian of person and property. This is 2020 SCC Online Kerala 19909. Arun Anthony George.
Because this is related, Mr. Lahiri, to the rights of a person,
Rights
of the person who is in comatose state.
Yes.
The rights of a person is always in rem. My rights are in rem. It's the whole world. If I have a right, so it has to be put into that time. So this is not an adversarial litigation between two parties that will be in person.
No. And my lord, paragraph 10,
Because why probate is judgment in rem? Because that's a dead person's rights,
right.
which is being exercised by
Yes.
some other. So his expression of wishes.
Expression. And
So that's,
even appointment of guardians and the guardians and
that
also
also,
is the guardian.
yes, has to be.
Has to be.
Anyway, very
This is the first judgment which says that it is to be appointed or not
rem.
in
right,
rem.
right.
Now, my lord, the next judgment which I have referred to is Arun George Anthony versus Union of India, where paragraph 10 it says for the first time, Arun George, 33 years of so and so, of the person and property of Hindu George. But the concept of guardian is of person and property. This is the first time person and property has been held. And then again, my lord, here also they have covered the petitioner shall submit reports before the Registrar General of the Court every 6 months, which shall contain particular of all transactions. And all the judgments have a backup mechanism. How will a person guardian will
Has
well,
to
even
be.
on the Guardianship and Boards Act, there is a
Yes.
mechanism. All laws which
Yes.
provides guardians have a mechanism of that the guardian should not
Accountability.
accountability of the guardian. But the next two judgments are of two different courts, my lord, which are 2023 judgments. Well, I'm referring to them, but these are two different high courts, my lord, passed
Your father is in his home or
in the home. But this is Telangana High Court, 2023 SCC Online TS 511. Paragraph 2, paragraph 4 deals with Shobha. Paragraph 6 deals with Uma Mittal. And paragraph 7 deals with Rajni Horiom. And then, my lord, paragraph 9. Prabhat shall be treated as accepted as guardian of husband, or authority shall accept her status and allow her to operate, manage movable and immovable properties. And then, my lord, the fallbacks and what are the guidelines. Now, the next is a judgment from Assam High Court, Guwahati High Court, which is reported in 2023, 1 Guwahati Law Reports 584. Again, all the judgments have been put in, my lord, I will not. But paragraph 19 is the
90.
operative portion. Then they have given the parameters. These are all the judgments which are there. But as of now, my lord, well, may I refer to one page? My junior has said page 50 at page P7.
Page
He has written down
of the writ petition?
of the writ petition.
Yes. It's 50.
50 P7.
Yes.
Clinical profile on admission presented with spastic quadriplegia and unconscious following fall and trauma back in 2015 when he sustained a fall following sudden collapse due to his inferior wall myocardial infarction and left-sided subdural hematoma and right-sided capsular bleed. The left frontal parasitic decomposed carcinomy done outside hospital. Patient taken had been treated with sepsis. This is what is there. My continuous flap, improved orientation, spastic problem with 4 limbs with plagia, and both lower limbs he is known to be hyperman. My lord, yes, plagia is paralysis. My lord, kindly takes P6 other 2 photographs. Well, we'll see the person's one side of the brain is gone.
That has been operated upon or caved in?
Caved.
This is not vegetative.
No, he is in coma. He can breathe himself. There is no, I will see, there is no.
No apparatus.
He can breathe himself, but he is in coma. So, my lord, as of now, okay, my lord, my junior has.
Thank you very much. Yes.
Now, my lord, what I would seek as of now is my lord will direct an appointment of a medical board who will go to my client's place to find out.
According to you, Mr. Lahiri, what should be the parameters of that examination by the medical? What should the medical board tell the court?
Tell the court that what is the present position, is he in comatose stage or not, and what is his present medical state.
The same thing can be repeated. How will you know about the?
No, but my lord will, well, I have
We
given,
translate it to plain English, Mr. Lahiri. Otherwise, the court cannot pass an order on that.
no, well,
The actual condition.
well, he is in a comatose stage.
Comatose, yes,
Yes.
definitely.
He cannot move. His eye movement is there. He can breathe himself, but he cannot move out of his bed, and he has no senses. And we have said that everything has to be done by a third person. So once a medical board appointed by this court, this honorable court, states that he is in a comatose state, then my lord, these judgments will apply, and then my lord, I will renew my prayer of appointment of a guardian in light of these judgments and there being no law. But my lord has to be satisfied that he falls in the parameters of being in a comatose state.
Yes. Should I ask the state? I think I should ask the state. That will be easier.
I am
So
for
judgment
the
will be the
respondent number 2, Union of India.
What is your stand in the matter?
My lord, I will submit only 2 points.
Absolutely. Yes.
My lord, lot of
Can you please take the microphone a bit closer to you? Yes.
My lord, lot of judgments and etc. has been cited before your lordship. My lord, a person lying in a comatose stage,
Yes.
for appointment, there is no specific law. My lord, my humble submission, where there is no specific law in this regard, the petitioner should approach the civil court, which is the proper forum for taking decision in this respect. Now, my lord, many judgments have been shown. I will submit only 2 things. My lord, in comatose stage, that one is persistent vegetative state means temporary. Another is permanent vegetative state means permanent. There is no question of coming back, or
One
that
is permanent, one is persistent.
yes, one is
Persistent is
persistent,
temporary.
another is permanent. Now, my lord, in the medical report, I don't find whether it is persistent or permanent. My humble submission before your lordship, a medical board should be given by the order of your lordship. They will submit the report, the status of the petitioner's father, whether in which condition he is lying, whether there is a persistent or permanent, whether there is a chance of his revival or that state of my lord comatose stage will continue permanently. So, my lord, my humble submission before your lordship that a medical board be appointed and a report is to be sought by your lordship from that board.
Thank you. And you are for the state,
No, Lordship, I'm for the performer respondents.
for the performance.
B.
Relatives.
The daughters and
The
mother and
supporting.
daughter.
Who is for the state? Somebody was appealing
There
for
and
the
then left.
Lordship, she has stepped out, right?
Pardon?
She stepped outside.
She was present. My lord,
Order record.
another thing I forgot to point out, lordship will kindly
Done,
say the
Done,
the
Kibble Sir.
affidavit filed by the pro forma respondents. It is something like giving power of attorney. And the last affidavit by the daughter affirmed in Milord Judge at Jaipur. Lordship will kindly see page 152. It was affirmed on 23rd. And the stamp paper was purchased on 3rd July 2003, affirmed on 23rd.
Page 152.
No, Lordship, it was affirmed on 6th of July 2023.
Lordship,
And-
kindly see the stamp
The
on
stamp,
the hip. It was 23rd June. And the stamp paper was purchased on 3rd July, 23. My lord,
No,
it
it
was
was
affirmed
23.
before purchasing the,
It will be 23, my lord. There's a dash there.
my lord, that is my doubt. I have pointed it out. Now your lordship to decide.
23rd June is the date of purchase. The date of
23rd June is-
affirmation is not very clear from this.
No.
Do you have the original of that?
Lordship, I can produce the original document on the next date.
The other affidavits you have checked up. The other
Other affidavits, my lord, my humble submission, it was something like giving power of attorney.
no, they are giving their consent.
are
They cannot do
only
better.
One line. Yes, we don't have any objection about FADCM.
They
But,
give less than that in hospitals. In hospitals, they have to give less than that. Anyway, thank you for pointing out. But
Thank you.
so produce the original. How soon can you produce the original? She has to send it and you have to produce the original.
Yes, Lord.
You must have it with you.
Lordship, I do not have the original document as of now, but I'll produce it on the next date.
When should I keep it? Tell me for that production only. I'll
Uh,
pass necessary orders on that date. We cannot be very late because of the condition of the person.
1 week time, Lordship.
1 week. Very. I'll keep it today. We are on
Next Monday, my lord, I think by that time it will come.
next Monday. I'll keep it next Monday.
Lordship will kindly fix it on.
On Monday, my lord.
Monday, I have.
Difficulty.
No, Tuesday, my lord. Monday will be monthly list and Wednesday.
Oh,
Day,
yes,
Tuesday.
yes. Tuesday.
Tuesday.
The petitioner, being the son of a person who is in a comatose condition, has applied by way of this writ petition for being appointed as the nominee stroke guardian of his comatose father, for carrying out necessary acts and transactions with regard to the person and property of his father. Full stop, next para. Learned counsel places reliance on several judgments and submits in all fairness, that a medical board be appointed to ascertain the actual physical and mental condition of his father prior to passing any orders. Full stop, next para. Learned counsel appearing for, you are for respondent number 2.
Respondent number 2.
Learned counsel appearing for respondent number 2 points out that within the contemplation of Order 32 Rule, Order 32 capital A of the Code of Civil Procedure, the prayers made in the writ petition ought to be decided by a competent civil court. So that apart, it is contended that there are two types of vegetative states, one, persistent, and the other permanent. Full stop, next para. It is submitted that unless it is ascertained by way of appointment of a medical board as to why as to the extent of the disability of the person concerned, there cannot be any appointment as sought for. Full stop, next para. Learned counsel for the respondent who further points out that the affidavits of the other relatives of the comatose person annexed to the writ petition are in the nature of powers of attorney. Full stop, that apart, the affidavit of the daughter of the concerned person annexed at page 152, it transpires, has certain irregularities, since the date of affirmation is not clear from the stamp. Full stop, it is submitted that the veracity of such affidavit ought to be ascertained. Full stop, next para. Upon hearing learned counsel for the petitioner and the respondent number 2, it is seen that the nature of the litigation is not adversarial. Full stop. Learned counsel for the respondent number 2 has raised an arguable issue as regards the maintainability of the writ petition, in the teeth of available alternative remedy by way of a civil suit. Full stop, the said question is undoubtedly, required to be decided at the stage of final hearing and passing final orders. Full stop. Next para. However, comma, for the time being, comma, a medical board and the appointment of a medical board appears to be the immediate solution to ascertain the condition of the patient. Full stop. Next para. However, comma, since a relevant objection has been raised by learned counsel for respondent number 2 regarding the veracity of the affidavit annexed at page 152 of the writ petition, comma, your pro forma respondent number
345. 456. Okay.
45 is which one is Varsha Jain?
Lordship, Varsha Jain is 4.
Four.
Proponent.
কি বললাম? Comma, the learned counsel, comma, the learned counsel for the pro forma respondents, comma, including the said daughter of the allegedly comatose person, comma, shall furnish the original of the affidavit, a copy of which has been annexed at page 152 of the writ petition on the next returnable date, full stop. For such purpose, comma, the matter is adjourned till August 8, 2023, when it will be listed fairly at the top of the list. Full stop. Next para, it may further be mentioned that although at the beginning of the hearing, comma, the state was represented through counsel, comma, at the time when views were being ascertained from counsel for the purpose of appointment of medical board, comma, none was present for the state, full stop. As such, comma, no decision on the appointment of medical board could be taken, full stop. Although learned counsel for the state makes an appearance at the time when the order is almost being concluded, comma, the appointment of the medical commission is kept reserved for the next date, comma, since orders have already been passed for production of the original affidavit annexed at page 152.
Obliged.
Column next. It is unheard of in the High Court's practice. Unheard of. I've never seen this throughout my practice career when I was coming here as a student and during my life as a judge. Please don't repeat this ever. Don't be obliged as a lip service. Follow that. You never do this in a court of law. Never. Column next, madam. আমাদের গুলো রেখে দাও, ওদের গুলো ফেরত দিয়ে দাও। হ্যাঁ, দিয়ে দাও, obviously. Please bring the books, Mr. Lyra, on the next question and shall try to procure.
Item 5.
Yes.
But item 5, the lordship was pleased to me that call it up yesterday and
Right.
Lord asked me to serve copy of the judgment to my learned friend, but Lord, he ran away so fast that my junior Lord could not catch him.
He has matters in several courts.
Yes, of course. That is the reason Lord, he probably had to go there, another court to attend.
My lord,
some-
only one thing. I have
Mr.
collected.
Kula, I'll hear the matter today.
Yes, I don't have. My lord,
Let us hear.
I have collected one circular of the government of West Bengal. Says that if 1 year a employee was disappeared, his family can apply for family pension with an submission of indemnity bond. That if ultimately that person's will return back and claim his dues, then he will have to return. Only that circular, but law is there. Law is not changed. It's Civil
Sorry,
Code
Mr.
108 Evidence Act, Civil Death Declaration, that was not changed. Only one circular is there
Lordship-
that I have collected.
So let me
Lord,
hear.
Lordship can record my undertaking in terms
So,
of the
in this
circular.
case, how long has he been missing?
That he has been missing Lord from 3rd January 2022. So it's been more than a year. Pursuant to that Lord, police complaint was lost, Lord, missing diary was lost.
What are you wanting now? Who are you? You
But
are
the wife.
You are the wife.
Wife.
What are you wanting
Person
now?
had Alzheimer's, Lord. In the old age, Alzheimer's, Lord, there are many cases when the person Lord goes out for marketing, never came back, Lord. So that's very unfortunate on the part of the family. They never got to see the person thereafter.
When was the diary lost?
The diary lost immediately thereafter on 4th. Thereafter, Lord, the petitioner did not stop there. The daughter of the missing person, he Lord, filed a habeas corpus petition in High Court, seeking Lord, further investigation by the police. The High Court passed orders in terms thereof further investigation took place. Finally, my lord, the writ petition was disposed on June 2022, whereby the High Court at this court, my lord, had held that, my lord, sufficient inquiry has been made and police cannot be held back for something they're not responsible for. Police cannot trace him. That's the final outcome of the writ petition, my lord. The police, in the final report submitted in that habeas corpus proceeding, police said that we had done whatever we could
not be traced out.
could not be traced.
And you are wanting now?
I am now wanting that the family pension. If the person comes back, but I am ready to give the undertaking. There is no problem. But the only one thing is that, my lord, if the person comes back, the person will be entitled to full pension, which will be double of the family pension, which person the wife can get now. So, my lord, the question of refund doesn't come here because the question will come whether, my lord, further money is to be paid or not. That is the only one catch. Except that, my lord, I comply with all other, my lord, formalities.
The family pension is monthly.
Pension is also monthly, my lord, the whole pension.
So if he comes back, he'll be entitled from when he comes back?
Yes. No, my lord, it will be treated that he was alive all along. He was, so my lord, it will go back to the date. It stopped, my lord, from January this year. Because, my lord, at the beginning of every year, life certificate has to be filed to, my lord, continuance of the pension scheme. This year, 2020.
He had retired when?
He has retired, my lord, on 2008, 29 February 2008. Till then, from 1st March 2008 till January 2023, he received pension, full pension, the person. Then
Certainly.
so that before a year, he went missing. January 2022, he went missing, but that for the entire year, he received the pension. His pension account received the pension for the whole year when he was missing. Thereafter, he's still missing. He did not come back. Now the wife says that pay me the family pension. I don't want full pension. I'm not getting full pension anyway because the person is missing. I can't.
No, but the difficulty, his pension account is still receiving the money.
No, not now. Till December 2022. Because in every year, beginning of the year, a person who is the beneficiary of a pension has to file a life certificate that he's alive. In 2022, that certificate was filed. So he received. But 2023 certificate could not be filed because he is not traceable at that point of time. So the pension was stopped. From January till July and now we are in August, no pension.
So you are wanting the pension from 3rd of
from
January
now,
22.
I obviously, I can't take
22
it back.
onwards.
Yes, from now onwards. Because the wife was completely dependent on the husband. No other means of sustaining herself. They are from Nandigram. They live in a village. So
No, there are other heirs also.
Daughter
is unmarried.
Unmarried, no, married daughter. Married daughter, that is why he's not a dependent.
She's not a dependent.
No.
You are the only dependent.
She is the only dependent, the wife.
What is your age about?
My age is 74 years.
His age was 70.
No, the petitioner, the person who has affirmed the affidavit.
Both are 74, right?
Yes.
Yes, sir. What is the circular, sir?
But I do not want to
circular I have collected somehow after yesterday.
Yes.
This judgment, I do not want to
No, cite it. Why not?
Once I can supply a copy. Copy আছে?
There a copy.
দুটো
Judge साहब के ना बाबा आगे।
স্যারকে কপি আছে কপি? That is of 2010 judgment, unreported judgment of our court, my lord. Lordship would kindly come to the next second page, my lord. The only one hard learned advocates for the parties. Memorandum dated 14th May 2019 short postulates that the family must lodge a report with the concerned.
That memorandum.
Yes, that I have collected.
It is there from 2008, my lord. I find it. So, and obtain a report that the employee has not been traced. It has also been noted that the family has lodged a GD and report has been obtained that despite efforts, employee could not be traced. Hence, in my view, if an application is made to the head of the office of employee in accordance with paragraph 5 of the said memorandum, the petitioner is entitled to grant family pension. Therefore, since the husband of the petitioner disappeared in 2006, considering the fact of circumstances of the case, the writ petition is disposed of by granting liberty to the petitioner to file an application before the Secretary Department of Municipal Affairs, such and such. But the respondent number 2, along with the report, if such application is filed, respondent number 2 shall send the same to the Secretary. Here, the application is already filed in our case in March this year.
No. In my instructions, application, my lordship's clients, the file now does not contain anything. Whether he has submitted the police
He'll
authority.
file a fresh application and
Yes,
give him the.
that doesn't contain anything.
Mr. Kole, have you given an entire copy of this to him?
Yes, ma'am.
Please hand over an entire copy of this to him. The one you handed over.
The circular.
Circular along with the indemnity bond, that format is there. He has to file in that format now. That is
That
the
I have
difficulty.
supplied. This is one copy. I have 2 copies are with me.
Please give a copy during the course of the day. I'll give
Yes,
that
yes,
direction.
that I can supply.
Tell me,
It's not
sir.
difficulties. It is within my WhatsApp or mail. I can forward it
Thank
and
you,
he
thank
can get it.
Learned
But your
counsel
lordship
for
kindly
the
consider me
petitioner.
that the law is this, my lord, he'll have to obtain civil
Counsel for the
declaration.
petitioner
It's an intermediary arrangement.
submits that she is a septuagenarian, full stop. Her husband, comma, who was also about 74 years of age, comma, went missing on and from January 3, 2022. Full stop. Please take your seats, all of you. January 3, 2022. Full stop. It is submitted that the petitioner's husband has been suffering from Alzheimer's disease and other age-related problems, comma, for which the said husband of the petitioner was not in a fully perfect mental condition at the relevant juncture. Full stop. Next para. The petitioner and her family, comma, accordingly, comma, lodged a general diary entry before the police authorities on the very next date, that is on January 4, 2022, comma, whereafter the daughter of the petitioner also filed a habeas corpus, a writ petition in this court, comma, seeking a writ of habeas corpus with regard to the missing husband of the petitioner. For next para, several orders were passed therein, comma, including an order on the police authorities to hold an investigation. For however, comma, ultimately the writ petition with the claim of habeas corpus was disposed of in the month of June 2022, comma, by taking note of the fact that despite best efforts, comma, the police authorities could not trace out the whereabouts of the missing husband of the petitioner. It is submitted that the said husband of the husband of the petitioner had last drawn pension in January 2022. Full stop.
December 2022. He is missing since January 2022.
Now, prior to January 2022, full stop. However, comma, the pension had been continued to be deposited in his account up to December 2022. Full stop. Next para. However, comma, thereafter, when a certificate was required to be produced, comma, the same could not be placed before the respondent authorities, comma, in view of the petitioner's husband having gone missing since January 2022. Full stop. Next para. The petitioner, comma, accordingly, comma, claims family pension on account of her husband to be deposited in the name of the petitioner. Full stop. Next para. Upon query, comma, it is revealed that the petitioner's daughter is married and there is no other dependent of the missing husband of the petitioner, comma, who was the original drawee of the pension account, comma, sorry, drawer of the pension account, comma, apart from the petitioner. So next para, learned counsel for the petitioner places reliance on a coordinate bench judgment, comma, reported, which is an unreported one, comma, passed in WP 8186 within bracket W of 2008, wherein the learned single judge placed reliance on a memorandum dated May 14, 1990 to observe that if an application was made to the head of the office of the employee in terms of the said memorandum, comma, such family pension could be granted to the said family member. For next para, learned counsel appearing for the respondent authorities hands over a copy of a memorandum dated May 14, 1990 and a subsequent memorandum dated July 17, 1992, comma, the latter containing a format of an indemnity bond, comma, which is required to be furnished under both the memoranda, comma, along with proof that the family lodged a report with the concerned police station and obtained a report, concerned police station. Full stop. Next para. A perusal of the memorandum dated May 14, 1990 indicates that the same stipulates that family pension, etc., may be granted in case where the employee stroke pensioner disappears, leaving his family, comma, subject to the fulfillment of two conditions, colon দিয়ে, নিচে Roman 1, the family must lodge a report with the concerned police station and obtain a report that the employee stroke pensioner has not been traced after all efforts had been made by the police. Semicolon. Next para 2 Roman 2, an indemnity bond IB capital should be taken from beneficiaries concerned to the effect that all payments received from government shall be refunded to government in the event the missing employee stroke pensioner reappears and claims his dues. Full next para. It is further provided that the above benefit may be sanctioned by the administrative department concerned. Full next para. In the present case, comma, the petitioner, comma, as expressed through learned counsel appearing for her, comma, is agreeable to furnish such an indemnity bond and documentary proof of a report having been lodged with the concerned police station and subsequent developments in that regard. Full stop. Next para. That apart, comma, since it is evident from the materials annexed to the writ petition, you have annexed all these things, the habeas corpus orders.
Yes, everything.
Annexed to the writ petition and the pleadings made therein, comma, that sufficient efforts were made by the family of the missing person stroke employee to trace out the said person. Full stop. Next para. Hence, comma, the respondents are required to disburse family pension in favor of the petitioner, comma, who is the sole dependent of the missing person, comma, subject to furnishing of the necessary paperwork by the petitioner as contemplated in the memorandum dated May 14, 1990. Full stop. Accordingly, WPA 17611 of 2023 is disposed of by directing the petitioner to file an appropriate indemnity bond, file an appropriate application to, it has to be filed to the head of the office,
A department,
Head-
head of the department.
to the head of the concerned department, comma, where her husband had been employed, comma, annexing therewith and furnishing therewith an indemnity bond as per the format which is annexed to the memorandum dated July 17, 1992, comma, which was published in pursuance of memorandum number 4671-F dated May 14, 1990, issued by the government of West Bengal, comma, finance department, comma, audit branch. Full stop. The learned advocate for the respondent authorities shall supply a copy,
But I have already supplied. Don't require, I have
has
already supplied.
supplied copies of the memoranda dated May 14, 1990 and July 17, 1992, comma, along with the format of the indemnity bond annexed to the latter, comma, to his counterpart appearing for the petitioner during the course of the hearing. Full stop. Next para. Upon such application, along with relevant documents, comma, including documentary proof that the family lodged a report with the concerned police station and the outcome of the same, comma, including the relevant orders and other paperwork pertaining to the habeas corpus petition filed by the missing person's daughter, comma, the same will be processed at the earliest by the respondent authorities and the family pension shall be disbursed in favor of the petitioner, comma, subject to the filing of such documents by the petitioner, comma, full stop. Such entire exercise, comma, including the commencement of disbursal of the family pension in favor of the petitioner shall commence latest within 1 month from the filing of the application by the petitioner. Full stop. Next para. It is made clear that the above order shall be subject to the probability subject to the eventuality that if the missing husband of the petitioner returns, comma, the parties shall act in terms of the indemnity bond furnished by the petitioner. No rest to cause urgency.
The affidavit of service will be kept on
If it
record.
is satisfied to the
But
I-
filing documents
I should indicate
and compliance of other formalities, if any, I do not know. Maybe Millard, certain formalities.
satisfy the concerned officer also. That is a formality also.
No,
but only I
Maybe
think
some-
But raise a bill for that.
Yes.
I should point out the respondent number 6, who is the commissioner of police, superintendent of police, that his service on him now received, but when I prepared this plot, he did not receive it, but he is not a concerned respondent. All the other respondents have been.
They have to consider. Mr.
Yes.
Kohli's client has to consider.
That means I should
You have
indicate
to
that.
annex the documents that at the
Yes.
relevant point you lost the right, and the habeas corpus documents are there.
Yes.
You are on a much better footing than the others.
Grateful.
After yesterday, I started Millard that the circular is there. Prior to that,
After
I
getting that
also-
order,
that
which was referred to in that order.
yes. That my largest friend Suza today. Yesterday,
Grateful.
Upgraded matter, item 6.
Mr. Chatterjee for the petitioner.
for the petition.
But I
beg to appear for respondent number 1, 2, and 3.
Milord, I appear for the state response. Milord,
On a very outset, I want to make submission.
I,
Both- Yesterday, I had a
Choose
talk
will
with-
make submission at the outset.
yesterday I had a talk with my learned junior sister, and she was not well. After corona, she was attacked twice. And
They keep it on some other day.
no, my lord, only thing, the instruction was not on that occasion. It was adjourned twice. But now she had the instruction right now. My lord, this is the
Milord,
second
Milord.
round. Acha, তুই বল বাবা, বল, তুই বল, বল।
Yes.
Milord, I actually received the instruction, voluminous instruction by the WhatsApp. I actually.
This is
seek
Right to Information Act.
Yes, and it is, I actually.
I'll explore your actuality. Let me hear him. Yes. Yes, Mr. Chatterjee, what is your grievance? First, tell me that I'll consider it.
My lord, this is the second round of litigation. I have asked in the first round some informations from the land department.
Yes.
That after 14T3 of the Land Reforms Act, one imposition, bar has been imposition on my retained property, and asking that what was the basis of those imposition of embargo. But I have asked some questions, my lord. Initially, I have preferred the SPIO, then fast appeal, then the final appeal.
Possible for inaction or refusal?
First appeal, it was considered, and 2 lines order was passed that
Rejected.
the information they have provided us, we have satisfied. But that was not the fact. And my lord Justice Moshu Bhattacharya was pleased to set aside that first appellate authority's
yes,
order
yes.
and remand it back. Again, my lord, I have given the opportunity of hearing. And my lord, now they are taking the plea of one judgment I have get, my lord. And it was taking the plea that the information which I have asked for, that was the information or suggestive in nature. In the first
Suggestive nature.
in nature. First round, they have understood everything. They have provided all the informations as per their submissions. But now they are taking the plea that they do not understand the meaning of
They
it.
again refuse.
Again, they refuse, my lord. Only I am appealing that what prompted them not
You prefer the first appeal against that also again.
my lord, in the first appeal authority refused.
The second time also.
Second time also.
Now you have a remedy in second appeal.
My lord, the thing is this, my lord, I am only praying to my learned junior sister also that land department putting some embargo on my own land after getting the opportunity that 14T3.
Can you please show me the query once, Mr.
My lord, kindly come to page 80. Lordship, kindly come to page 89. And this is the order. It will
So
be
your question, your
these
information.
are the questions. A, B, C, D.
Why was this? How were you instigated to file this? I mean, there was a refusal by them to do anything
Yes, my lord, they are refusing me that,
in writing.
yes,
Refusal in writing.
yes.
Can
my
you
lord,
show me that refusal also?
yes, no, that
What
later
was
I can show
the
it.
genesis of this?
But I cannot. yes,
Otherwise, these are legal questions also in a sense.
yes. This is the one.
এই অরিত্র লেখাপড়ায় মন দাও লেখাপড়ায় মন দাও দুষ্টুমি না করে Mr. Chatterjee, these are legal questions. Why are they duty bound to answer this? I mean, whereas it appears from the report, they have said, presently they said rice and oil mill is not functioning, not used for the purpose for which it was allowed to retain. That is one aspect of the matter. The other is attempt to convert. So both are it's your prerogative to know the law on that.
Yes, my lord, the thing is this.
Why should they answer you on law? You
Because
file
of
an
the-
application or a writ
Yes, my
petition,
lord, I
you'll
have
answer
filed
in
the
the-
application. This is the one.
right
aspect,
to
my lord.
information
My
is
lord,
not.
why I am saying subject to kind sanction, kindly allow me to make one submission.
Yes.
My lord, our question was that you should have some basis to putting this particular 6(3) of the Estate Acquisition Act, my lord. It will not, is a law. But question of law, it's a
Mr.
fact,
Chatterjee,
my
they
lord.
have cited the West Bengal Land Reforms Act.
Yes,
They have cited that Land Reforms Act, and they give two grounds: you have not used for the purpose, and
Well,
that
that is subject matter of challenge.
conversion. Yes.
Yes, that is subject
So
matter of
challenge
challenge.
that. That is the subject matter.
But my lord, if I don't have any document, my lord,
You need not
kindly
have any
appreciate-
document on the law. You are saying what is the statutory provision which do not confer, under which provisions of law they cannot. They are not compelled to answer this. This does not fall within right to information.
No,
You can,
what I have asked,
no,
my
Mr.
lord,
Chatterjee,
but-
you can challenge this refusal.
My-
In that they'll have to give the answer before a court of law
my lord,
or an authority.
yes, my lord, but on the other hand, kindly appreciate
This
one
is
more
this is
aspect,
a.
my lord.
I mean,
But my lord, I'm asking to myself, man,
I'll
is there
refuse you.
any-
I'll give you liberty to challenge this. But this is also, I mean, 4 years have elapsed.
My lord, I have also
So you are
given reply.
going on filing these RTI applications just
Because
to.
of that, but I don't have any document.
You need
I
not
will-
have any document. They won't give you any document on this question. Which provision of law, which under what is.
And there should have some basis
No.
that they can proceed this initiation of this proceedings, my lord. They could have supplied me, but my lord, off the record, I can make this submission, but these records are not at all available. These records are not at all available. That's why I'm getting.
What record will be available? You have not asked for any record.
No, my lord, the question which I have raised, last two questions,
Acha.
my lord, kindly
Cannot be
appreciate, my
as to why the said land cannot be sold to others, although the recording of the nature.
lord. If it is written property, my lord, then I can sell. If
You have
they
not
some
asked for
basis-
that record also.
Ask for the
Record, any particular record. You have said why the said land cannot be sold. This is undoubtedly suggestive.
And my
although
lord,
the
the last
recording
one.
of the nature,
And
this
my
is
lord, the
very
last-
suggestive.
and my lord, the last one.
Whatever was recorded in the schedule in connection with proceeding.
Yes, my lord, there I have asked, my lord. They can
Why
provide
this?
me
Whatever was recorded in the schedule, this is in connection with C.
in the first.
Mr. Chatterjee, they are correct. For a change, the state is correct.
Is my, I cannot.
Not the state actually. This Mr. Shah's client actually is correct.
Just ask client.
No, my lord, this is perhaps not my client's report. I am appearing for the second appeal.
Second appellate authority.
Oh, you are only second appellate authority. Very good. Then you are also not correct.
She is.
No, Mr.
Our
Chatterjee.
client.
File a proper application challenging that refusal.
That liberty I have. That I
You
have.
don't have probably now because 4 years have elapsed in the meantime. You're trying to buy
I
time.
cannot also
When did you file?
demonstrate some factual aspects. also
Mr.
before
Chatterjee,
your
when did you
lordship.
file this application first?
Yes, my lord. I have suffered a lot.
2022.
In the first round, I suffered at least 1.5 years to get this order that it has been set aside. No hearing could not done.
Submitted an application on 15th of February 2021.
Lordship.
I'll dispose of the petition. Let her remain continued with her volume, Ms. Maiti.
Well,
She'll go
may I
through
get
that
the
in the interregnum, but I'll dispose of the
May I get the copy of that? But
No.
no, it's a privileged communication. But
No copy of what? The law. You're not
Hello.
entitled to anything on this.
my lord, I
And definitely not on these questions, definitely.
because man, I have tried my luck to get the
What is Justice
information.
Bhattacharya's order? If I'll have to bypass that also. No, that was probably only a direction to reconsider.
Yes, that was earlier order was set aside and to send it for reconsideration.
Then-
Giving here.
This is a fresh consideration of them.
Yes.
So I'll record that, Mr.
No, there is a
Chatterjee, I'll
page
dispose it.
69.
Anything was observed on merits, Mr. Chatterjee, in that order?
No, my lord.
I
my
don't
lord,
think so
kindly-
because at that stage it would be premature.
My lord, in the first page of the order, my lord, at
Yes,
page
yes.
69, upon perusing the order, it is
Devoid
clear,
of reasons.
impugned order devoid from reason. That is no. In the merit, it didn't make any comment, my lord.
I'll record an order, Mr. Chatterjee. Please challenge the refusal. I'll keep this. Can I keep this on record also? I'll give you liberty to challenge this on before an appropriate. Learned counsel for the petitioner submits that the petitioner made an application asking for certain information from the SPIO concerned. Full stop. The same having been refused, comma, a first appeal was preferred, comma, followed by a second appeal. Full stop, next para. However, comma, the petitioner could not get any satisfactory reply, and the information sought by the petitioner was refused on certain cryptic grounds, comma, primarily on the premise that the questions were of suggestive nature. So the next para, the matter went up to a coordinate bench of this court, comma, which directed a rehearing of the application of the petitioner by the SPIO, comma, which was again followed by a refusal. Push of the petitioner, comma, being thus constrained, comma, had to move the first appellate authority. Push up learned counsel submits that the refusal of the respondent authorities is
It was refused by the first appellate authority.
very well. I'm sorry.
My-
The refusal by the first authority was palpably dehors the law, and it was the bounden duty of the authorities to provide the information as sought for. Full sub next para, heard learned counsel for the parties. Full sub next para, the queries made by the petitioner are as follows. এটা পেজ 89 এ থেকে ডি পর্যন্ত সেটা একটু করে দেবেন। আইটালিক্সে আছে পেজ 89 of the writ petition, small a to small d. Italics এ।
Only thing is, the first appellate authority is not the first authority. He is the second authority. SPIO is the first authority.
No,
First appellate
it
authority
was
did not
refused
refuse.
by
The
the
first
first-
authority refused. Mr. Saab,
app-
everything
not
is all
by
right.
you.
Don't worry. Yes, next para. It transpires from the first two questions made in the said set of queries that the same are directly on provisions of law. Full stop. In both the said queries, comma, the petitioner has asked for the relevant statutory provisions on which the authorities rely, comma, which the authorities are not bound to furnish under the scope of the Right to Information Act. Full stop. Next para. Query small c within bracket is, comma, as rightly pointed out by the first authority, comma, is of a suggestive nature, comma, since the petitioner states therein that why the land cannot be sold to others, তারপর within double inverted, although the recording of the nature of the land was specified in connection with proceeding under section 14 capital T within bracket 3 bracket closed of the West Bengal Land Reforms Act, comma, 2005 double inverted close question mark. Full stop. Next para. Query small d within bracket is connected with small c and states that whatever was recorded in the schedule in connection with proceeding initiated under section 14 capital T within bracket 3 of the West Bengal Land Reforms Act, comma, 1955, a whatever থেকে 55 পর্যন্ত এটাও ডাবল ইনভার্টের মধ্যে, comma, kindly indicate as to why the said land cannot be sold to others. Full stop. Next para. The said suggestions or the veracity of the same are not required to be disclosed by way of information within the contemplation of the Right to Information Act 2005. Full stop. However, comma, if the petitioner is aggrieved by the parent action stroke inaction of the respondent authorities, comma, which prompted the petitioner to make such queries, comma, the petitioner is at liberty to challenge such action stroke inaction in an appropriately formulated legal proceeding. Full stop. Upon the query of court, comma, learned counsel for the petitioner hands over a notice under section 4 capital B within bracket 2 of the West Bengal Land Reforms Act 1955 dated November 13, 2019, comma, whereby the subdivisional land and land reforms officer, comma, Shuri within bracket Shodor intimated the petitioner inter alia that the petitioner had allegedly attempted to convert lands from rice and oil mill to dwelling house stroke housing complex, etc. for promoting purpose, and that the said rice and oil mill was not functioning for last few years. Full stop. Next para. Since the petitioner controverts such stand taken by the subdivisional land and land reforms officer, comma, it is always open to the petitioner to challenge such findings as well as the inaction, which was the genesis of such communication by the said authority. Full stop. Hence,
My lord, that the notification against which I was asked to give reply, my lord, can it be possible for your lordship to record that I have give reply to that, my lord?
Where is that?
My lord, this is, yeah.
It further transpires that the said communication between the authority and the petitioner arose from a notice purportedly under section 6 within bracket 3 of the West Bengal Estate Acquisition Act, 1953, vide memo number 6 within bracket 3, bracket closed, capital C case oblique 1558 stroke SDL commercial land shortened and LRO within bracket S stroke 19 dated November 21, 2019. Full stop. Next para. Everdin. Accordingly, WPA 1787 of 2023 is disposed of without interfering with the order impugned herein, but granting liberty to the petitioners to take out a properly constituted challenge before the appropriate legal forum and or this court, against the concerned notice dated November 21, 2019, as well as the communication dated November 13, 2019, which are the genesis of the dispute raised by the petitioner. Full stop. It is made clear that the petitioner shall also be at liberty to challenge any other consequential or ancillary acts or inactions on the part of the authorities, if related with such impugned action of the authorities, in the petitioner's challenge. Full stop. The merits of the contentions of the petitioner and or the respondents on the proposed challenge have not been gone into by this court, and it will be open to the appropriate forum to decide on such issue independently and in accordance with law. No rest for certain.
But if your lordships kindly observe one line more, the second appeal pending before the second appellate authority has got infructuous. Since the order against the second appeal has been preferred, that order has been set aside by the coordinator.
Mr. Shah, you have to cite this order before the second appellate authority and get that order from the authority. This matter is over. I'll come back in 10 minutes for the next matter.
Item 7.
Lordship, I am appearing on behalf of the petition.
Yes, please. All have been served?
But I am appealing for the
Lordship.
respondent number 2, only the respondent number 2.
Two. Yes.
But-
Rest have been served?
Yes, yes.
Yes. What is the matter?
Matters Lordship, the petitioner's husband working at Transport Planning Department. At the time of his death, at the time of his lifetime, he took a loan from the SBI Life. And at the time of taking his loan, he opted a SBI Life Insurance policy.
Hmm.
Thereafter, petitioner's husband died on 17/9/2022. After his death, he opened a pension salary account before the SBI Tangra branch. But after opening, he saw that his
Before death, he opened that, master.
no, after his death. After his death,
After his death, who opened?
wife
Obviously, yes.
opened a pension.
Right, yes.
Thereafter, opening the bank account, he saw that his account was blocked. He made a representation before the concerned authority that his husband was dead, but thereafter, no step was taken to the authority to unblock my account. And thereafter, petitioner kindly come to page 19, Lordship. He made a detailed representation to the authority. And thereafter, kindly come to page 22. The SBI Life Insurance, they made a letter to the petitioner that they are adjusted my SBI Life Insurance, which was loan was received by the petitioner's husband. But no steps were taken on the basis of the same. I cannot receive my pension due to my account was blocked by the concerned authority. And I went to the manager, they told the until and unless I do not the loan, the until and unless they do not unblock my bank
Page
account.
22, you said their reply?
Page 22,
22
Yeah.
is something else.
Something else.
SBI Life Insurance.
No, 22, they don't say this thing.
No,
That
said
they have
that
adjusted with some loan.
adjusted my life insurance.
Where is that
And-
stated? Page 22?
Kindly, this is with reference to your letter dated 8/5/2026, seeking reconsideration of the death claim request submitted against the caption policy of the please accept our yearly
Heartfelt condolence for the said
condolence
device.
for the same Mr. At the outset, we apologize for the inconvenience caused for you in this regard. In this regard, we wish to inform you that the death claim will be put up in
The repudiated death
Yeah.
claim will be
Claim
put up in the next claims
next
review committee.
review committee. But I do not know why the bank,
So what do you get this thing? Actually, he took loan and then.
he took loan.
So then you
But-
must be knowing that. That's why
He
you
took
said
loan, but
that
I
is
do
not cited by the bank as a reason. They are saying that they will put up the matter for before the claim review committee.
authority, but my.
It is fair enough.
No,
That
no,
is with
Lordship,
regard to the
my-
repudiation.
My
That is with regard to the repudiation, my lord.
my contention is this: after opening my bank account, they block my account. I do not know why they
The
block my
claim review
account.
committee,
Until
My lord, this,
does she have a right of hearing before the claim review committee?
my lord, this writ petition is with regard to the, my lord, her account has been blocked by the
Blocked.
SBI. But I am appealing for the SBI life insurance. In fact, I have nothing to say in this writ petition. In fact, SBI life insurance shouldn't be a party hearing because page 22, which your lordship has gone through, my lord, this is with regard to repudiation of her claim. She has come up before lordship because her account has been blocked by the SBI.
Yes, Lord,
That is what-
until and
So, my
unless
lord,
my
life insurance, my lord, in fact, I shouldn't have been made a party even here.
No, you have replied to them that the repudiated death claim will be
Lordship.
put.
That is separate, but her account has been
Who has
blocked by
repudiated the death claim?
this has been reputed by the LIC. I mean the
You.
yes, SBI life
Lordship.
insurance.
Why did you repudiate that?
Lordship,
That
this is
because
Let me hear that.
she did
Why
that-
did you
that-
repudiate?
because the person while making the claim, my lord, he did not disclose that he had chronic disease with regard to
no,
his
Lordship.
that is why.
This is not. If
But
this-
he made
if-
suppression. He had, my lord, he
If
had.
there is suppression, then this letter was not written by the by that person.
But you are mixing up causes.
Yes, that is what I was trying to say.
Lordship,
Both of us cannot
My lord,
speak
no.
together. Please take a seat. Let me
My lord.
address her for the timing.
Lordship,
Please come to page 10 once. Please come to page 10. Your entire relief sought is on release the dormant bank account,
yes,
blocked
Lordship.
account, let it be made active again and all this.
Yes,
You have
Lordship.
but not even challenged the repudiation of claim.
No, Lordship. My,
So you're not
Yeah,
challenging
no,
page
no,
22 at
no.
all.
this is, I am just insert this here. By my,
Your where is the repudiation of your where is the blocking of account? What is the communication regarding that?
Lordship, after opening, this is my, Lordship, kindly come to page 16. This is my bank account. This account is opened by the wife after death of my husband.
Where is your communication, your complaint regarding their blocking the account?
No, Lordship, this is not there.
Then-
Lordship, I went there.
Asking for a
Lordship,
relief,
I went.
annexing something.
Yes,
else.
Lordship, this is the main problem.
So file the writ petition afresh then. File a proper writ petition. The writ petitioner claims that she is the wife of a deceased account holder with the respondent bank. Full-stop. The present challenge has been preferred against.
Lordship, I state in my writ petition, I state that.
Freezing,
Kindly come to page 10.
freezing stroke blocking an account of the petitioner. Full-stop. Next para. It transpires that the annexures to the writ petition pertain primarily to the repudiation of a death claim made by the SBI Life, nothing in which regard has been sought in the relief portion of the writ petition. Full-stop. Next para. In view of no prayers having been made against the SBI Life, no such relief can be granted within the scope of the present writ petition. Full-stop. Insofar as the alleged blocking of the account, the correspondences between the petitioner and the bank on that regard do not find place in the annexures. Full-stop. Although the petitioner has annexed certain documents to indicate that a bank account stands with the respondent bank, there is nothing on record to show that the same has been blocked or any complaint filed in that regard. Full-stop. It appears that the present writ petition mixes of causes of action against the SBI Life and the SBI itself. Full-stop. Accordingly, WPA 15028 of 2023 is disposed of with liberty to the petitioner to file a properly constituted fresh writ petition, annexing all relevant documents, both in respect of the alleged blocking of the petitioner's account with the SBI, as well as seeking reliefs with regard to the repudiation of the claim of the petitioner made by the SBI Life. Full-stop. Next para, the relief, the merits of the cases made by the parties have not been gone into by this court.
My lord, may I submit only one thing?
Annex the relevant documents regarding the refusal of the SBI to unblock that account. 1, your communication relating the blocking of the account. 2. So these will, the papers will have to be annexed.
Actually,
The
Lord-
relief remains.
Lordship, I understand.
And please annex, you have annexed their documents, but sought no relief.
Lordship,
There.
I understand. This is not drafted by me.
Obviously, it is not drafted by you.
Lordship, kindly give me liberty to file a fresh letter to the bank to consider
That
my.
liberty is always there.
Lordship, kindly indicate
আচ্ছা
that.
কি relief-টা কি দিলাম? Disposed of by granting relief to the liberty to the petitioner too? যেটা বলেছি আচ্ছা যা লিখেছি তারপরে লাস্টটা দিয়ে দিন। It is made clear that the petitioner will also be at liberty to correspond afresh with the respondent bank and come up with a properly constituted challenge against further cause of action, if any arises in that regard. Thank you.
Lordship.
That is always there, in fact. No liberties, it's a subsequent cause of action.
Grateful to Lord.
Thank you.
Item 8.
Yes, Mr. Haldar, what is the matter?
May it please your lordship. This is the application for shifting of meter and my lord kindly see the my lord's order dated 30th June 2023. And on the basis of that order,
What was the inspection for the purpose of
no,
shifting?
that is the,
Feasibility of shifting. What is your report?
that is
Kindly kind of take up the.
You have got a copy?
yes,
Respondent of 5?
yes.
You have got a copy?
I got.
Yes.
Last paragraph at page 1, minor. And
Yes.
Last paragraph.
Mr. Mukherjee, take the microphone.
Last paragraph at page 1 of the report and the last paragraph of page 2. You can see the whole second page, minor. The petitioner during inspection has shown one newly constructed room.
Why are they seeking the shifting? Why are you seeking the shifting?
The condition of the meter.
For that only.
That.
Respondent number
And
5,
locked
your
by-
meter is also located there.
No, my lord, as far as my instruction, my it is
So
not.
let it be shifted.
Let it be shifted, my lord. The only difficulty I am facing that
What is your difficulty?
difficulty is that, my lord, from the report, I also saw that my client has not appeared. She has not even given any instruction to me.
But what was the initial difficulty?
Initial instruction was her instruction was that without interfering the common passage or on the contravening the common right of the partition, that can be shifted. That I stick to that.
I'll direct you to give it, shift it to the new meter room, and you will be at liberty to approach the district magistrate if you have any grievance with that. It transpires from
Only for the consent from all the consumer who are having meters.
What are we?
who else is having? Your consumers, you know, Mr. Mukherjee.
There are 3, my lord. Soumitra Bera Mukherjee, Obhijit Mukherjee, and Sri Nirmal Chandra Bose. And Ashish Bose.
Abhijit Mukherjee is the petitioner. Soumita Vera Mukherjee is the. And Soumita.
Mr. Mukherjee, why didn't your client take initiative in this? Because the safety has also been looked into by you. Meter room is your property. Meters are your property.
It has been put into lock and key, my lord.
That is a different aspect. Mr. Mukherjee, you should have asked the other consumers also to have their meters shifted. You do it in many cases. It's your prerogative. If your inspection shows that yes, it's in a dilapidated condition, your meters are situated there, you have a right over the meter. You are the owner of the meters. So it's your prerogative, Mr. Mukherjee, to initiate a shifting process by intimating all concerned.
But my lord, unless and until they consented to it, my lord, we cannot shift, my lord.
There is no question of any consent. You have to write to them for that consent, Mr. Mukherjee. It's your prerogative. You have to enforce that. You should have come up before this court. A report filed today by the district engineer, Howrah district of the CSA Limited, be kept on record. Push up, it appears from the said report that the condition of the existing meter room is extremely dangerous and dilapidated, and the ceiling shed is also damaged, through which water is entering into the meter room, especially during monsoon, exposing the entire room to danger. One of the meters, it is stated, is hanging dangerously and is prone to electrical hazards. Next para, a new lock has been affixed to the meter board room by police personnel and kept the key with the police personnel. Next para. However, it has also been indicated in the report that the petitioner has shown during inspection a newly constructed meter room, which can be used as a meter board room for the purpose of shifting the existing connections, which would take care and redress the apprehension of hazards. Next para. However, learned counsel for the CSC Limited submits that unless consent is obtained from all the consumers whose meters are located in the existing meter room, the shifting cannot be undertaken. Next para. learned counsel for the respondent number 5 submits that the said respondent is only aggrieved if the common passage or any portion occupied by the respondent number 5 is disturbed by way of giving such shifting such meter. Next para. It transpires from a comprehensive perusal of the report of the CSC Limited that the CSC itself has complained that the existing meter board room is in a precarious condition, which may give rise to electrical hazards at any moment. Next para. It was expected that the CSC Limited, being the licensee, ought to have itself initiated due proceedings asking the consumers to have their meters shifted to an alternative location and providing a space for the same, since the CSC Limited has exclusive domain over the meters concerned and is also duty bound under the law to ensure safety and security. Next para. Undoubtedly, the CSC Limited is not required to go into the question of whether there are electrical hazards beyond the area which is within the authority of the CSC Limited, the present predicament concerns the meters as well, on which the CSC Limited has full control. In any event, the hazardous condition in which the current meter room is in, cannot permit of further delay in the matter of shifting the same to the new meter room, which has been pointed out by the petitioner. However, for the ends of justice, all the present consumers having their meters in the current meter room shall have to have access to the new meter room as well. Next para. Accordingly, WPA 15033 of 2023 is disposed of by directing the CSC Limited to shift the existing meters, electricity meters, affixed at the existing meter room of the premises in question to the new meter room pointed out by the petitioner as reflected in the report filed by the CSC Limited today. Such shifting shall be completed within 1 month from date, prior to such shifting, all the consumers of the CSC Limited who have existing meters in the current meter room shall be notified by the CSC Limited, which notices shall be given preferably within a week from date, indicating the said shifting, citing this order and the safety hazards in the current meter room, in such communications. If necessary, the CSC Limited would be at liberty to annex server copy of this order with their communications, also citing the hazardous condition and annexing a copy of the report filed today by the CSC Limited to such communications. Upon such communication being made, the shifting shall be concluded within a month from date. If any resistance is offered by any from any quarter, it will be open to the CSC personnel to approach the officer in charge of the Bhattra police station, that is respondent number 3 herein, to provide adequate assistance to the to the CSC personnel in shifting such meters, at the cost of the petitioner. If necessary, any lock or other hindrance put up at the existing meter board position or the new meter room shall be removed by the CSC, by the police personnel, for enabling CSC Limited to undertake such shifting work. Next para, it is further made clear that upon the shifting being concluded, the petitioner, the CSC Limited shall ensure that a lock is put to the said new meter room, with keys being handed over keys of the said lock being handed over to all the consumers having their meters shifted to the said meter room.
Regarding the keys,
You will do.
CSC, how can we take responsibility? Because kindly peruse your lordship's earlier order. Kindly you will peruse your lordship's earlier order, madam. In respect of this only, the my lord has directed the police to keep the keys. Kindly see.
That is regarding the previous meter room, the existing meter room.
Yes,
They'll break open their own key.
yes, but my lord, in respect of the lock, my lord, how can the
You will put the
CS,
lock and hand over copies to her.
my lord, it will
It's
be,
your meter room.
my lord, the meter room is in
You have
respect of
sole
the,
exclusive
my
access to the meter.
lord, meter room is the domain of the consumer, my lord. Only the meter is ours, my lord.
তাহলে যেটা সিএসসি বললাম লাস্টেরটা the CSC shall ensure না কি put the padlock put
My lord, let that be directed to the police.
না না
authority.
কিসবিং না সেন্টেন্সে কোটা বল
যেটা পুলিশ
না এখানটা CSC limited shall ensure that থেকে কেটে দিন
হুম।
being concluded by the CSC limited comma the petitioner shall put a padlock in the presence of the CSC personnel and hand over keys to the lock affixed to the said meter room in the presence of the CSC personnel after such shifting is concluded, comma, to all the consumers whose meters are shifted to the said new meter room. No rest to cost, Sergeant.
And the shifting cost will bear by the petitioner. Cost of.
No, CSC will be.
CSC.
Just see the expression of Mr. Haldar's face. Shifting charges, we act a line at them. The shift, just act a line. The shifting charges, comma, needless to mention, comma, shall be borne by the petitioner.
May I make one inland?
আবার
Along
May
with,
make a prayer, but I may not allow it.
well, along with the CSC person, let the police be also there. But it will, then again, it will be difficult. When police, direction of police
No,
assistance
no,
is there,
police cannot
let
be
the
there.
police be present there, along with the CSC.
If
man.
something happens after that, I'll direct the police to go. Justice Sengupta will direct.
Man, we kindly add that
no,
word. man.
No, no. The moment you finish the shifting work is over, they will put the padlock, they will arrange for bringing the other consumers and hand over.
But over there only I am asking, my lord, if
Why
I'm
should the
praying,
police be there? Why should the police be there?
as your lordship, please.
I'll direct the learned advocate on record and the officer of the CSC to be there. I can direct that if you want.
I'm grateful. man.
Item 9,
9.
Well, I'm for the state.
State, acha, which is for the petitioner. Yes,
For the petitioner, my lord, I serve the copy to all the respondents, my lord.
right.
My,
If it is MMR, I'll reject it now. Too many MMR matters. This is also MMR.
not same MMR, my lord.
Different MMR.
My lord, kindly, my lord, I am already granted license case page 7, my lord. Already license was issued in favor of me, my lord. One person is MMN and Kaji, my lord, the license and Sonod. But Sonod was not issued, my lord. I made an application, page 8, my lord.
But this you had to come to the read court. Why don't you supply this one?
My lord,
My lord, kindly see, my lord. Next page
Yes,
9,
yes.
next page 9, the.
Don't make piecemeal submissions. Make your total submission, then I'll go to the other side. Yes, page 9.
My lord, at page 7, my lord.
You are also there.
I'm there for the state.
That's what.
My
Yes.
lord, page 7, my lord, license was issued in favor of.
7 license,
Yes.
8 your application,
Yes, sir.
then
9, my lord, the concerned authority who is in charge in the government, my lord, joint secretary, made an inquiry to the 5 senior persons of the police station area. All the persons 9 to 18, my lord, gave a report to the joint secretary that the petitioner is the fittest person to get the Kaji.
how does that question arise? You have already got a license that has not been
Yes,
cancelled.
that is license, and my lord, Kaji is Sanad, my lord. Sanad was not given, my lord. The next page, my lord, page 8, my lord. Prayer
That
for-
you have stated, that I can guess.
Yes, my lord.
Yes, what about this?
This has to be disposed of by the principal secretary of the law department. And this is the act, my lord.
My lord, now it is changed, my lord. The respondent number 2 is in chair, my lord. Since it is not. Now the law is respondent 2 is the authorized person to do all
The
this.
instruction is that.
All this, my lord. And I have no problem, my lord.
You are saying which secretary?
The principal secretary of the law department.
Principal secretary of the law department.
Yes, on basis of this
Now the
1980
law
Act,
is
1880.
changed in the last 6 months, my lord.
There is no secretary law department.
Yes, my lord, which is the new.
My
new post.
instruction about two
And I have
weeks
no
ago.
problem, my lord. Whatever is submission, my lord, but the
in so many cases, my lord, they have submitted before your lordship in state of principal secretary also for correction, the secretary to the lord, and that is new post.
And
for
I the
handling-
entire respondent authorities to do it. I'll direct them to ensure.
Particular, my lord, then my lord, principal secretary we give him.
Learned
Then-
counsel.
He has a
appearing-
problem with the principal.
I think so. I think so. That is a. Learned counsel for the petitioner contends that the petitioner was issued a license to function as a Mohammedan marriage registrar, which is annexed at page 7 of the writ petition. Subsequently, however, the required sonod, SANAD, which is to be granted to the petitioner on the basis of such a license for functioning as a Qazi, was not granted. The petitioner accordingly applied for such Qazi Sanad, which has not yet been given to the petitioner. Next para, it is submitted that subsequently the Joint Secretary to the Government of West Bengal wrote
The citizens of Basanti police station area.
to the citizens of the police station asking to enlighten the Joint Secretary Apostrophes Department regarding the necessity of appointing the petitioner as Qazi in the area. It is submitted that the overwhelming majority of people in the area stated that such appointment was necessary. Next para, be that as it may, learned counsel for the state submits on instruction that the principal secretary law department of the government of West Bengal is the concerned authority to grant such sonod. Although the principal secretary law department has not been implemented, respondent number 2 is the secretary, law department of the government of West Bengal. In any event, since the state is a party to the writ petition, the purpose of justice would be subserved if the respondents are directed to ensure that the sonod is issued to the petitioner at the earliest. Accordingly, WPA 15400 of 2023 is disposed of by directing the respondent number
2, my lord.
Number 2 to issue a sonod in terms of the license granted to the petitioner, for performing duties as a Qazi / Mohammedan marriage register in the area covered by the Basanti police station. Such sonod shall be issued as expeditiously as possible, preferably within 3 weeks from date. Next para, in the event no rest
And kindly makes it respondent authority.
very good.
Instead
Respondent number
number
2 টা না করে না respondent authorities করে দাও. The respondent authorities shall issue.
And
Thank
in the event they have something against the petitioner, my lord, the reason should be.
No, license is there, you have to give a sonod.
I know that.
Then you file a recall application.
New motion, item 11.
Yes, please.
10.
11.
10.
10 কি হলো?
10.
ডাকো 10. Yes.
Item 10.
Is my application against the order of ombudsman, my lord. But it has been sent, my lord.
Copy is not yet returned. Should I take it up next week or week after that?
No, next week.
Next week.
Tuesday, my lord.
The service has not yet been completed. Accordingly, let the matter stand adjourned till August 8, 2023. Next Tuesday.
Eleven.
Yes.
Affidavit of service.
Mr. Rai, you are for the respondent?
I am for the rest.
Yes. What is the matter? All respondents served.
All
Right.
respondents of lordship. affidavit of
Please take the microphone a bit closer to you. Yes. What is the
Lordship, this
grievance?
a matter where the petitioner's mother died of electrocution, lordship.
Compensation.
Compensation, lordship. I have 2 judgments of this court, previous judgments.
Where
One-
is the application made by you?
Lordship. The application is page number 14, lordship. Actually 13, lordship. Effective part, page 14. Made an application. She died in the year 2020, lordship, during the lockdown period, 15/6/2020. Application made on 7/6/2023, lordship.
Why did you wait for so long?
Lordship, it was the COVID period, Lordship, 2020. It was.
Your mother was earning anything?
Lordship, she went there to cut grass for the cattle, Lordship. She's a farmer. Very poor.
Yes, Mr. Rai, you have to consider this.
Yes, my lord. Because
Consider and give a reply.
my instruction is that no, I have over phone that there is already an inquiry was made and there was my lord husband of the victim has given witness there.
Then, Mr. Rai, I'll direct you to file a short affidavit in opposition so that you can disclose all documents.
That in that event, my lord, let the matter be considered. That will
No, that will not serve any effective purpose, Mr. Rai. I'm being very frank, because if I direct that, they'll have to make another writ petition to say that you are not giving, and those grounds will be considered. So say whatever you have to say here, so that this person can get a relief here or be refused here. Let them know their fate here.
Yes.
The petitioner's grievance is that the petitioner's mother, while cutting grass in a particular area, was electrocuted due to
falling off
the negligence of the WBACDCL footstep. The death occurred in the year 2020, sorry. Footstep, the application was made in June 7, 2023. Footstep, next para, learned counsel appearing for the respondent submits that apparently there was an inquiry regarding the death and compensation might have been disbursed in favor of the husband of the deceased. Footstep, however,
no, there is no compensation disbursed because it is not from our line. Therefore, my lord.
Lordship.
So you said husband?
No, husband, my lord, given evidence to that effect. His husband has given evidence.
তুমি যেখানটা স্টপ করলাম না, আরেকবার বলো। না, কম্পেনসেশন থেকে কম্পেনসেশন থেকে কেটে দাও, এন্ড এর পর হবে। And the husband of the deceased person gave evidence therein. Footstep, you are denying that.
Lordship, I have no instructions to that effect.
Very well. Footstep, next para. Learned counsel for the petitioner, on instruction, denies such stand taken by the respondents. Footstep, since a factual question has arisen, instead of relegating the petitioner to further litigation by asking the authorities merely to consider his representation, the respondents are directed to file their affidavit in opposition within a fortnight, Mr. Rai.
3 weeks.
Within 3 weeks from date. Footstep, reply, if any, shall be filed within 1 week thereafter. The matter shall be listed in the monthly list of September 2023 for hearing. Thank you.
Grateful, Lordship.
Affidavit of service filed today. Yeah.
12.
I appear on behalf of the series.
No, I'm for the private response.
Yes. Petitioner?
Yes, my lord, for the purpose of getting new connection, my lord. My connection was already.
Mr. Kasimuddin is resisting. Who is resisting? The private respondent?
Private respondent, my lord.
Why resisting?
I don't know, my lord. Petitioner is own daughter, my lord.
Oh,
Own daughter, my lord.
that is sufficient reason. You are the daughter. She is the mother.
He's a father and brother, my lord.
Father. What has she done, Mr. Kasimuddin?
My lord, the property belongs to me, father. Now, we allowed my daughter and son-in-law, but my main grievances against the son-in-law, to stay in my property on the first floor for a temporary period.
So that is a crime.
No,
that is a crime. You let them stay.
I'm not against the reconnection. Now, kindly see.
No, that's a crime on your part. You let them stay. So you have to suffer now. Let them get electricity. Why not?
No, but kindly see the allegation, which I am updated. How could he make this?
What is the allegation?
Paragraph 5.
That is Mr. Kasimuddin, because they were advised probably, because otherwise it
And
will
kindly see,
be, it will be splitting of load.
And kindly see the page 11, the letter of complaint addressed to the police and the authorities, that on 10 February 2022, more than 1.5 years back, I forged a signature and got the electricity disconnected. Though this is absolutely a bogus allegation, because as far as my instruction is concerned, it was disconnected because of the non-payment of the electricity meter.
Your electricity meter?
In her name. My electricity meter, I've got 2 electricity meters, one in my name, one in my son's name. They are using my electricity. I've never objected to that.
Oh, she had an electricity connection in her name.
in her name and that was disconnected on the ground of non-payment of the electricity charges. But the allegation which they have, serious allegation that I forged the signature, I got electricity surrendered. This I'm against that. I've already filed a suit in the city civil court for recovery of possession that is pending there. That is a separate issue because the son-in-law is insisting me to transfer the property in his name. That is the main grievances. So we have filed a suit for recovery of possession because the crime I have committed, allowing him to stay on the first floor. But this allegation, Lordship, is not acceptable, Lordship. And moreover, they're not even allowing me to access to the property, to the meter board also because ground floor is in my position. Only first floor I've given there. Now me as a senior citizen, my father.
You are on the ground floor. The meter must be in the ground floor.
But they put the padlock there. They put the lock there. I'm staying at Kadaya Road.
Understood.
This is in College Street, New Market PS. I don't have the access to the, I'm being a father, I've been deprived. Let them pay the charges. They have electricity. I'm not standing on the way. I cannot stand on the way on that.
Otherwise, these allegations definitely.
These allegations is something serious because they will then subsequently use somewhere else also.
These allegations, this complaint was made after you filed the eviction suit or the other way around?
This allegation they have made after my suit was filed. Because this letter is of 28 March 2023 when I issued a notice of you leave the premises.
Let me hear the case. Take your seat, Mr. Kasman. Yes.
In respect of paragraph 4 also I say that.
Be faster, use the microphone, and next time you take a computer printout, use me and hang it on the microphone. That's your cost.
In respect of paragraph 4 also, this is a wrong statement. Whether we kindly find that according to paragraph 6, first line, he stated that on 20th March 2023.
Wrong on what score? The number of family members.
Kindly see the annexure P1, that is of 2018.
Yes.
10th of May 2018. And he is saying in paragraph 6 that the electricity line was disconnected on 20th March 2023. The fact is, my lord, we disconnected the line on 1st of January 2021 in respect of non-payment of electricity. The total amount, total outstanding till date is 30,830. And in terms of regulation 55, 4.6.1, since 180 days have relaxed.
They have applied for a new connection again.
They have still not applied.
My lord, I have
Their prayer is for reconnection. The meter is itself not there because for 180 days it has, it was lying in the disconnected manner. We have removed the meter.
If that be so, my lord,
they have to pay this outstanding.
Yes, somebody take a seat. You assess the costs which should be imposed.
Yes, my lord.
What are the costs for filing the writ petition? I will dismiss your writ petition with costs.
No, my lord. Kindly.
Why not? Give me one reason.
Kindly consider, my lord.
Definitely no.
Kindly consider, my lord.
This is an abuse of the process of court. Just an abuse of the process of court.
I shall pay.
You're tormenting not only your father. I'm not on morality, on legality also. They file an eviction suit, you take out a complaint, and you are saying that it should be reconnected, although it was disconnected for your non-payment.
My lord, I tender my unqualified
Not
apology.
your unconditional apology. You don't have any fault. Your client has all the faults. No. I'll impose costs.
No, my lord. Kindly, my lord, consider. Kindly, my lord, consider.
Consider what?
Consider, my lord. Kindly consider the aspect, my lord. Kindly consider reconnection of the electricity board. I shall pay enter the dues here and now, my lord.
The petitioner contends
Here and now, my lord. I shall pay.
that the petitioner's father, that is the private respondent number 5, had the petitioner's electricity connection disconnected through the CSC personnel, which it is submitted that the petitioner, for some unknown reason, is being refused a reconnection of the electricity connection by the CSC Limited, prompting the petitioner to prefer the instant writ petition. First of next para, learned counsel appearing for the private respondent number 5 submits that the private respondent number 5 is the father of the petitioner and accommodated the petitioner and her husband in his own premises at 130, Collins Street. First of next para, however, subsequently due to the conduct of the petitioner and her family, the respondent number 5 was constrained to initiate an eviction suit against the petitioner and her husband. First up, during pendency of the suit, a complaint was lodged by the petitioner to the officer in charge of the Newmarket Police Station, comma, as well as to the General Manager Commercial of the Central Regional Office CSC Limited, comma, wherein it is indicated that what was that page, Mr. Kasimuddin?
Page 11. 11 and 12.
Right. Alleged that on February 10, 2022, in presence of the petitioner and her husband, comma, the CSC men came at about 10:11 a.m. to disconnect the electric meter standing in the petitioner's name. Full-stop, on objection being raised by the petitioner and her husband, comma, it has been alleged, comma, the CSC men showed the petitioner and her husband a letter bearing the petitioner's signature. Full-stop, it has also been alleged that the petitioner was stunned and vehemently stated that the signature appearing and written as Farah Naz was not written by the petitioner. Full-stop, allegations have also been made that a portion of the letter contained forged signature of the petitioner. Full-stop, next para. The petitioner has further alleged, comma, it is pointed out by the respondent number 5, comma, in her complaint that her brother Aftab Alam, comma, father Mansur Alam, comma, that is the respondent number 5, and stepmother Anjuman Alam stood there with the CSC men, and the said Aftab Alam told the petitioner that he had, within double inverted, subscribed, double inverted close, the signature of the petitioner in the letter. Full-stop, next para. Learned counsel for the respondent number 5 submits that all the said allegations are afterthought and merely intended as a backlash to the petitioners to the eviction suit filed by the respondent number 5. Full-stop, that apart, comma, it is argued that the petitioner's own electricity connection was disconnected long back due to non-payment of electricity charges. Full-stop, next para. Learned counsel for the CSC Limited submits that the petitioner has incorrectly alleged that on March 20, 2023, the electricity connection of the petitioner was disconnected by the CSC Limited, comma, although the said connection was severed as long back as on January 1, 2021. Full-stop, next para. It is submitted that the petitioner left huge arrears in electricity charges, comma, for which the disconnection was effected. Full-stop, next para. As per the prevalent regulation, comma, after the expiry of 180 days from such disconnection, comma, the initial contract between the petitioner and the CSC Limited has already spent its force. Full-stop, if the petitioner is to apply for a fresh electricity connection, comma, the petitioner is required to pay all dues as well as other statutory charges for such purpose. Full-stop, next para. A comprehensive perusal of the materials on record as well as upon hearing learned counsel for the parties, comma, it transpires that the petitioner's own electricity connection was disconnected as long back as on January 1, 2021 for non-payment of electricity charges. Full-stop, next para. Thereafter, the petitioner, comma, instead of repaying the dues and other statutory charges for restoration of such connection, comma, has come up with the present writ petition, comma, by making baseless charges against the private respondent, comma, seeking a restoration of the said disconnected electricity supply. Full-stop, next para. In the teeth of the prior disconnection for non-payment, comma, the petitioner is guilty of suppression of material facts. Full-stop, next para. The very basis of the writ petition is malafide on the part of the petitioner, comma, who has made certain baseless allegations against her father as well as against the CSC authorities, comma, in spite of having not paid the due charges of electricity to the CSC personnel, and having her electricity supply disconnected long back. Full stop. For such suppression of material facts and even on merits, comma, the petitioner is not entitled to any relief in the present writ petition. Full stop. Accordingly, WPA 17586 of 2023 is dismissed on contest. Full stop. Next para, the petitioner shall pay costs of rupees 5,000 each to the CSC Limited as well as the respondent number 5 as a token censure, CENSURE, for the suppression of material facts to court as well as frivolous allegations having been made against the said respondents. Full stop. Such costs shall be paid to the concerned respondents as per above direction within a week from date. Full stop. Liberty to mention the matter even after disposal in the event the costs are not duly paid by the petitioner.
My lord, kindly minimize the cost, my lord. Kindly minimize that. My lord.
What can be less than 5,000?
No,
I
my
was
lord,
thinking
kindly,
in the,
kindly minimize
in the
that.
range of 50,000. I deleted the last
no,
zeros
no, my lord,
because of
kindly.
maybe you are not in a very good financial condition. 5,000 is minimum.
I'm good.
Just a token.
13.
13, yes.
May I please, your lordship?
Please.
Lordship, petitioner bank is. Lordship,
State. 14.2.
Yes, lordship. Lordship, kindly.
Borrower
state-
implemented.
Yes, lord. Yes. All were served. Kindly come to.
Have you checked up service on the borrower? Come to page.
Kindly come to page number 18, annexure P3. At the bottom, lordship, your lordship would find that it was received at the office of the district magistrate on 18th of April 2022.
Yes. So where is the receipt date?
Lordship, at the bottom, lordship, received. Page number 18 at the bottom.
Date is 25th April.
2022.
22, that's right. No, what is the stage of your application? Just
Lordship,
pending.
it has not been disposed of. It was left pending, which was supposed to be disposed of within a period of maximum within a period of 60 days. Your lordship knows.
I'm passing directions. The grievance of the petitioner bank is that despite the petitioner having applied under section 14 of the Surface Act 2002 against the private respondent stroke borrower and having written with regard to expeditious disposal of the same long back, comma, the district magistrate concerned is not taking any steps with regard to disposal of the same. Full stop. Heard learned counsel for the parties. Full stop. Learned counsel for the petitioner is justified in submitting that the law contemplates an outer limit of 60 days for disposal of applications under section 14 of the 2002 Act. Full stop. It is seen from the communication annexed to the writ petition made to the district magistrate that the same was received by the district magistrate as long back as on April 25, 2022, full stop. There is nothing on record to justify the considerable delay in disposal of the application, full stop. Para, accordingly, WPA 17652 of 2023 is allowed, comma, thereby directing respondent number 2, that is the district magistrate, comma, district Purbo Bardhaman, comma, to immediately dispose of the application filed by the petitioner bank under section 14 of the Surface Act against the private respondent numbers 6 and 7 by passing appropriate orders and taking appropriate steps for possession in terms of the Surface Act. Such entire exercise shall be concluded within an outer limit of 1 month. Now, within the outer limit of August 31, 2023. It is made clear that the above time frame is peremptory and mandatory, and the district magistrate shall adhere to the same on the basis of written communication of the learned advocate appearing for the petitioner, coupled with a server copy of this order, comma, without insisting upon prior production of certified copy of the same.
Lordship, kindly record that affidavit of service may be kept on record.
Affidavit of service kept on record. প্রথমে একটা দিয়ে দিও। No arrest to cause urgency.
Can you extend 2 months, my lord?
No. Outer limit is 60 days. 60 days.
That too.
You have exceeded more than 1 year.
My lord, there are several cases pending. That's why, my lord, I am praying for.
No.
Grateful.
14,
Page 18, kindly.
Yes.
Page 18. Lord, I'm appealing for the respondent 1, 2, and 3. This
You have deliberately chosen this learned advocate on record, miss. Yes, page 18. No, he has moved competently in other matters also. So he's shaping up well. Yes, Mr. Dr. Bhatt.
But these
MMR.
letter- 1A. But this letter was issued, kindly see state governments have accorded approval for appointment of Saugupta Ara as a temporary MMR in Chandanagar Police Station, District Hooghly. I am accordingly to request to take necessary action for appointment of Saugupta Ara. Well, in spite of having the letter, appointment was not given. Then I moved the writ petition, page 20.
Yes.
Court passed an order, kindly relevant to page 21, directing the respondent to give appointment. Page
To
21.
take appropriate steps in terms of appointment, yes, very well, yes. Right.
In terms of that, my lord, kindly see page 22. Lord, it is very much missing in my writ petition, Lord. Your Lordship, kindly see that has not been
It's the
annexed.
most crucial page, miss.
Lord, it is missing in my prayer, Lord. No, it has not been given, Lord.
But state was a party there.
It is there, Lord. I wanted to have, Lord. So since I have not found, so I did not call them.
That's it.
So let me have the copy of that. I'll call them. Your Lordship, kindly just let me have the instruction. Kindly see this order. You know what's clear? Appointment has been given. License was not. Let us see that. I can call the respective authorities. Kindly see.
Oh, that order has been complied with, but
This order complied with. In the last line, your appointment will be affected. That very annexure has not been annexed in this writ petition, in my writ petition. Are Baba, আমাকে দেখতে হবে তো। I need to have the instruction for the appropriate authorities. Without seeing that, how can I make my submission? Last line, kindly. Appointment has been given. The Lordship, kindly allow me some time. I'll come back with the instruction. You just give me the copy of this. You have not annexed. This is your fault. You have not annexed in my writ petition. You have served the copy on the GP office, but you have not annexed that one. No, why should I tell lie? Try to rely on me.
no, page 22 has been given to you. Let us ignore that.
My lord.
Order of the previous bench. Please come to page 22, P6.
P6 is not here in my writ petition.
No, that is the order of the court is not there.
Order of the court is there. The P6, not your Lordship.
The
kindly
order
come
of the
to
court
paragraph-
is there.
No, your Lordship, kindly come to paragraph 4. Paragraph 4 and the prayer.
No, P6 page 22 is not there in his copy.
No, it is not there in my writ petition.
Learned counsel for the state points out at the outset that a copy of a vital annexure, that is annexure P6, is missing from the copy served on him. Full stop, since the said copy is crucial to the adjudication of the writ petition, comma, the learned advocate on record for the petitioner shall serve a copy of the missing annexures to the learned advocate appearing for the state during the course of the day. Full stop, let the matter stand adjourned till day after tomorrow, that is till August 2, 2023, when it will be listed fairly at the top of the list.
Lord, may I have 1 week time next week, any day, Lord. Maybe on my part.
তাহলে, day after
Next
tomorrow না
week,
করে,
any day, Lord. On Monday, your Lordship can keep
till
it.
August 9, 2023,
Fine.
when it will be listed fairly at the top of the list for passing orders. Affidavit of service filed today be kept on note.
Get full,
9th, clear 1 week, more than 1 week in fact, so you can complete.
Mine, get full.
Fairly at the top of the list, I'll pass orders.
9th Mine. August.
Pardon?
9th August, Lordship.
9th August, yes.
Give me
I want to cross the combined list date. 7th will be the combined list date.
Mine. তোমার একটা কপি দিয়ে দিও আমাকে। দেখুন দিদি।
Give a copy during the course of the day. But
Yes, yes, I will. My lord, get full to Lord.
Mr. Bhattacharya will do that.
Hello?
Mr. Bhattacharya will do that. Yes, call me.
15,
I'm for the
Usual
petition.
combination, usual order, Mr. Mukherjee.
No, my lord.
Exemplary costs on the CSC limited
My lord,
because of your
I-
appearance.
my lord, this is in respect of news service, my lord. My lord, kindly come to page 13, my lord. We have written to them that there is already a service exist. But my lord, only difficulty is that, my lord, if my lord, this has been given today morning to me. If my lord, kindly give me 1 day's time, my lord, let me come up with specific instruction. my lord.
On the prayer of learned counsel for the CSC limited to seek further instructions, the matter is adjourned till August 3, 2023, when it will be listed under the same heading. 3rd August.
Lordship,
It of fail at the top. Fail at the top of the list. These are small matters can be done up.
I am grateful.
Thank you.
Lordship.
Yes, call on.
My lord, item number
60.
4, item number 16, sorry, my lord.
16, yes.
My lord, I just got the instruction that it has been served today at 11 o'clock. I have not yet received the copy of the writ petition. Kindly, my lord, accommodate 1 or 2 days time.
You're for?
Respondent number 4. I have just in WhatsApp, I have just received the.
Who is for the petitioner?
My lord, I'm for the petitioner, my lord, I was.
When should I keep it? Tell me.
My lord, tomorrow, my lord, I was.
Day after
Yeah,
tomorrow.
My lord, we have not been served also, the CASC.
The respondents apparently have not yet received copies of the writ petition. Push-up, let them attest and adjourn till August 3, 2023. 3rd August, day after tomorrow.
Grateful, my lord.
Item 17.
Yes, sir.
Lord, I appear for
Lord,
the
I am
petition.
for the WBSETCL.
Yes.
But this is a very short matter.
Mr. Kola, please. Yes. Yes, Mr.
My Lord, at an earlier stage, my Lord was pleased to pass a direction at page 24. Kindly have a look to that, my Lord. But there is a complicated thing called, my Lord, deviation settlement mechanism, where, my Lord, the generators and distributors or other licensees of electricity, my Lord, when they draw power from the state grid or inject power in the state grid, my Lord, to maintain some discipline, my Lord, certain schedules are fixed. If you overdraw, then you have to pay. If you under inject, then you have to pay. If you underdraw, you get money, like that. Now, there were certain grievances which were raised by us, which were not being settled, because, my Lord, there was a central regulation which was in force till January 2022. From January 2022, my Lord, the state regulation comes, which is at variance with, my Lord, the central regulation. Therefore, my Lord, we thought that we, being very small players, we cannot be put at par like WBACDCL. Therefore, there should be some amendment in the rules. Therefore, my Lord, finally we came before this court. And, my Lord, there was a suggestion from the part of the Electricity Commission that we must first go before the commission. And, my Lord was pleased to, my Lord, direct us to go before the commission, which is the order at page 24.
Yes.
First paragraph is they'll decide. Second paragraph is made, I'll go on paying that I'm doing. Now, please take me to the second paragraph. I'm sorry, second page.
Yes.
Page 25. In such view of the matter, so and so is disposed of by granting liberty to the petitioner to move before the WBERC with the dispute as agitated in the present writ petition, if necessary, by filing an additional statement and or pleadings before the WBERC. WBERC thereafter shall decide the issue in accordance with law upon giving an opportunity of hearing to all interested parties as expeditiously as possible. It is clarified that the merits of the present challenge have not been gone into. All is due. But pursuant to my Lord's direction, my Lord, we had filed, my Lord, an additional representation on 13th of April, but that is not on record, my Lord, we have pleaded so. My Lord, now, my Lord, the difficulty is, my Lord, we need, my Lord, some time from your Lordship, my Lord, some fixed time, because, my Lord, in fact, my Lord, one of our major grievances have got, my Lord, solved by this time in the natural course, where, my Lord, the WBERC, looking into the incongruity between the central legislation and the state legislation, Millard had brought it down from a particular date. That we have said, Millard, I don't want to trouble your Lordship with all those, Millard, that may not be necessary at this stage to address your Lordship, Millard, on the merits. But today, Millard, I was praying only this, kindly fix a time.
Fix a time for completing that exercise as directed earlier.
Completing that exercise. And, Millard, we have got certain additional grievances, which of course we have said, Millard, in our.
It was only in March. So the regulatory commission is in, I mean, they are hard pressed of time.
Millard, the problem is, Millard, I suffer in several crores every month. And I'm a very, very small, Millard, licensee, which operate in an area where DVC is operating, Millard, WBACDCL is operating, and I would be practically, Millard, washed out. But I'm already out of pocket by, I do not know how many crores. 12 crores.
You have already served on the.
This is, we have served, we are paying, there's no dispute on that. If your Lordship may fix some time, this is the only, Millard, short purpose.
Learned senior counsel appearing for the petitioner submits that the petitioner is a small operator stroke licensee of electricity who saw on a previous occasion, a grievance was raised before this court by way of a writ petition, pertaining to deviation settlement mechanism, which is in force. Which of next para, this court, by a direction dated March 24, by an order dated March 24, 2023, had disposed of WPA number 1179 of 2023 by granting liberty to the petitioner to move before the West Bengal Electricity Regulatory Commission, if necessary, by filing an additional statement or other pleadings. Full stop. It is submitted that the petitioner has done so and has also been going on paying the current electricity charges as observed in the said order. Full stop. Next para. However, the limited grievance in the present writ petition is that the ERC is taking considerable time in deciding the issue which has been raised, before it, thereby putting the petitioner to much financial hardship, since the petitioner operates on a comparatively small scale and is being adversely affected. Full stop. Next para. Keeping in view the despite service, none appears for the WBERC, although the petitioner and the WBACDCL are represented through counsel. Full stop. Next para. It is seen that even on July 31, 2023, when the matter was called on for hearing, the WBERC was unrepresented. Full stop. The affidavit of service on record, which is kept on record, shows that the WBERC was duly served. Full stop. In view of the innocuous nature of the prayer, further service is not directed on the WBERC. So the next para. Accordingly, WPA 16985 of 2023 is disposed of by directing the WBERC to dispose of the dispute raised by the petitioner, by considering all pleadings and relevant materials and giving adequate opportunity of hearing to all parties, in terms of the direction dated March 24, 2023, passed in WPA 1179 of 2023, as expeditiously as possible, preferably within 2 months from the date of communication of this order to the WBERC. No rest to cause urgency.
But only one thing, my lord, the case number is OA 418 of 22-23. My lord, but in the prayer portion at page 15, your lordship would find, my lord, the case number.
Is WPS 8 is disposed of by directing the WBERC to dispose of the such and such. That is case number OA-418/22-23. Thank you.
I'm grateful.
18.
Yes.
My lord, I am on behalf of the petitioner.
Yes.
Petitioner is a small farmer and his only income derived from the farming. So in front of his house, the electricity authority fixed a unused electricity pole. There is no wire and no service connection from that pole, because electrification of that area is already had been completed before 10 years. Now, the petitioner ran from pillar to post to redress his grievance, but the respondent authority never reticent regarding this matter. Finding no alternative, petitioner approached before the district magistrate, and district magistrate also requested the WBSCDCL to remove the pole. After that, they had nothing done. Then they are finding no alternative. Petitioner come before the writ court with clean hands, my lord.
The district magistrate passed a written order or just verbal?
No, nothing.
So you're asking for a shifting of that unused electricity pole?
Unused electricity pole at the middle of the road. So the petitioner's bull cart not carrying paddy to his courtyard. Even no patient can also carry to the ambulance.
Yes, Mr. Mukherjee, remove it. How soon? We'll charge this person for this unused electricity post.
My instruction is different, but this has been used and this has been done in 2017. At that time in 2017, no objection was there. And my lord, kindly see, in 2022 April, this is the first objection. And from that pole, my lord, electricity has been given to the villagers. Now, my lord, there is a drain and the panchayat drain and the...
Have you given a copy of this to him? Please hand over a copy. What is this? This is your instruction or what? Yes.
Now, your lordship can direct the district magistrate to decide because, my lord, the pole has been erected in 2017 and 2022 April, we first received the objection. And my lord, from that pole, the electricity connection has been given to the villagers. Now, my lord, if he shift the or remove the pole, my lord, that will create a problem, my lord, because the villagers are getting electricity from that. And moreover, my lord, kindly see the picture, the handwritten, my lord, the sketch, although it is not very legible, but my lord, the drain and my lord, there is a road, Panchayat road. Now, my lord, we don't know whether this land belongs to him or not. Kindly, if your lordship direct the district magistrate, he can decide the, my lord.
What is ROW?
That I also in confusion just now, my lord, I received.
ROW may arise in case, is it a threat or an abuse or what?
No, my lord, not
Is that much you should know, sir. Put it in the Google search and see what is ROW. I want to ascertain. Use your phone. Apart from the usual meaning, of course. I mean, ROW abbreviation, just put it like that.
ROW টা মনে রাখছি ROW এই পাঠিয়েছে one is showing right of way, but my lord, I have to confirm, my lord, I am not sure.
Maybe right of way. Maybe right of way. Yes, they are taking several points. One is that they say, but have you stated here that that is being used for power supply?
Yes, my lord, kindly see, my lord.
It was erected for power supply. Is it being used?
Yes, my lord, because the line is there, but that if the shifted, my lord, there will be a problem. My lord, kindly see.
You have stated complainant wants to shift one electric. Please read out your. Read from the second paragraph, Mr.
Yes, my lord. The complainant wants to shift one electric pole. That pole was erected 5 years ago for power supply at village. At the time of pole erection, no such complaint received. There is a Panchayat drain and electric pole is beside this drain. Other side of the drain is road. Local people use this road. The complainant claims that electric pole and Panchayat drain are at his own place and pole need to be shifted from his land.
This court cannot decide. The writ court cannot decide. I'll relegate it to the district magistrate.
My lord, there is no alternative way. In
That the
COVID
district
pandemic
magistrate-
situation,
Yes.
carry the patient from his house to ambulance, but with bare hand.
I'll put it up. I'll put it to the. You took the first objection in 2022, 5 years after it was erected. Whatever.
No, my lord, there is enough alternative way. The electrification already completed. You local
did you take-
miscreants use that pole for
If you are so
for running tea stall, just like.
If you are so aggrieved, why did you wait for 5 years?
No, I already objected.
That counsel for the petitioner submits that the petitioner is aggrieved by the erection of an electricity pole, comma, which is unused. Full stop, next para. It is contended that the same is being used for unauthorized purposes by local antisocials, but not for giving electricity to any person. Full stop. Moreover, comma, the location of the electricity pole is preventing the petitioner from smooth access of his bullock carts and, if necessary, patients in and out of the petitioner's premises, which are situated adjacent to the pole. Full stop. As such, comma, the petitioner sought for shifting of the pole, which was not acceded to by the respondent authorities. Full stop. It is contended that although the petitioner approached the district magistrate, comma, who requested the shifting of the pole, comma, the same was never done by the WBACDCL. Full stop, next para. Learned counsel for the WBACDCL files a report purportedly issued by the assistant engineer and station manager, comma, Labpur, LAB, Labpur Customer Care Center, comma, WBACDCL. Full stop. The same indicates that the pole was installed in the year 2017 and the first complaint was received only in April 2022. Full stop. That apart, comma, the same is being used for giving electricity connection to the local village. Full stop. Moreover, comma, it has also been stated that the electricity pole and panchayat drain are. What is the meaning of this piece of? Moreover, sentence second, moreover, it is stated that there is a panchayat drain and electric pole beside the
Sir,
drain
my lord, apologize. Panchayat drain is now constructed.
on the other side of the road. Full stop. Next para. Be that as it may, comma, since a dispute has been raised, comma, for deciding which factual considerations have to be weighed in, weighed in, comma, it would only be prudent for the concerned authority, that is the district magistrate, comma, who is required to decide the issues. Full stop. Next para. Accordingly, WPA 17/666 of 2023 is disposed of by granting liberty to the petitioner to approach the respondent number 4, that is the district magistrate, comma, Shuri, with the grievance of shifting the pole as raised herein. Full stop. Next para. Upon such approach being made, comma, the district magistrate, comma, if he feels necessary, comma, shall direct a report to be furnished on an inquiry by the local block development officer.
Block land and land reforms.
Block land and land reforms officer, and proceed to decide the issues raised in accordance with law, comma, upon giving opportunity of hearing to both sides, comma, without being influenced in any manner by any of the observations made herein. Full stop. It is expected that the district magistrate shall dispose of the dispute so raised, comma, so raised as expeditiously as possible, comma, positively within 6 weeks from the dispute being referred to the magistrate by the petitioner. No order is to cause urgency.
Only thing,
Apologize, my lord.
district magistrate Birbhum. Shiuri is the place where the office is situated. Although in the malad,
Only district magistrate.
District magistrate, Shiuri যেখানে বলেছি district magistrate, comma, Birbhum. Situated office is probably at Shiuri Shodor or something.
Shiuri Shodor.
Anyway, Birbhum. District magistrate.
Much obliged, my lord.
19.
Yes.
My lord, I am for the petitioner. My lord, first of all, I obliged before your lordship that in the matter, the private respondent was not included as a party due to technical error. If the lordship grant liberty to allow me to include the private respondent as a party, then I include the private respondent in
What
this
about
matter.
service on the other respondents?
Yes,
Have you
my
served
lord.
the other respondents?
Yes, my lord.
Where is your affidavit of service? You have checked up whether all have been served, address received. No, not properly served. One of the respondents has not been properly served. Check up which.
Yes, my lord.
Keep a copy, always keep a copy of this, of the affidavit of service with you for future reference. Always keep a copy. I'll direct you to file this affidavit along with the press service. On the prayer of learned counsel for the petitioner is permitted to implead a private respondent who, according to the petitioner, is a necessary party as well. Full stop. Do you know the address and the details of the private respondent?
Yes, my lord.
What is the address and the details of the private respondent? Do you know?
Include
How can you implead? You will have to carry out the corrections in the cause title.
No, my lord.
Accordingly, the petitioner is permitted to implead the private respondent within a week from date. Full stop. Necessary consequential amendment to the cause title of the application, writ petition, shall be carried out by the learned advocate on record for the petitioner during the course of the day. During the course of the coming week. Full stop. Next para. A copy of the writ petition shall be served on the added party, and an affidavit of service to that effect shall be filed along with the affidavit of service regarding service on the other respondents, comma, on the next date of hearing. Full stop, the matter shall be listed under the same heading in the monthly list of September 2023.
Grateful, my lord.
Item 20.
My lord, I am appearing for the petition.
Service has been affected.
Yes,
What is the matter? You're for the union? Shanandi?
My lord, petitioner, my lord, has applied for the issue of passport, my lord, by an order, my lord, by the respondent authority. My lord, petitioner's passport, my lord, was impounded, my lord. Thereafter, my lord, petitioner preferred an appeal along with section 5 application. But, my lord, no response was given, my lord, neither any communication nor any reply was given by the, my lord, concerned respondent. Thereafter, my lord, several RTI application was
By
preferred.
RTI?
It's regarding the status of the appeal, my lord.
Acha. Who is
Status
the
of
appellate
appeal.
authority?
Appellate authority, my lord.
Which respondent?
That is, my lord, passport
Officer?
Regional passport officer.
No,
my
my
lord.
lord, they are not the appellate authority.
And my lord,
The
chief,
ministry-
No, my lord, chief passport officer, my lord. Chief
The
passport.
Central Ministry is the appellate authority in terms of section 11 of the Passport Act. So my London friend has, what my London friend is submitting, it has not been pleaded in the petitions. No prayer has been made, no pleadings have been made.
What is the prayer made to?
Prayer made only the
Cancel the
order
import-
impugned, the should be set aside and quashed. But with regard to section 11 applications, there should be some prayer or some pleadings. But that,
My lord,
what
I
is the
have pleaded,
status of the
section 11 application has been, my lord, appeal has been filed, my lord. I have pleaded, my lord. Lordship, kindly see.
only one paragraph, my
my
London
lord.
friends pleaded that the section 11 application is pending.
Lordship,
But what is his grievance? What is his prayer?
Lordship, kindly see paragraph
Has
7.
not been mentioned there.
Lordship, kindly see paragraph 7. Paragraph 7, my lord, I have stated, my lord, the grounds of appeal also, my lord. Lordship, kindly see paragraph 7. In the petition, my lord, I have also stated the grounds of appeal, my lord.
So direct that appeal to be decided.
Disposed of.
What will be a reasonable period, Mr. Nandi, for
No,
deciding?
my lord, within 8 weeks, my lord. Very well. Within as
I
your
didn't
lordship,
say
within-
unreasonable period. What is a reasonable?
within 4 weeks, we will send.
Learned counsel for the petitioner submits that the petitioner's passport was impounded for being thus aggrieved, the petitioner took out a challenge under section 11 of the Passports Act 1967 before the Chief Passport Officer, CPV Division, Ministry of External Affairs. However, till date, the same has not yet been decided. The petitioner approached for information with regard to the status of the said challenge several times under the Right to Information Act 2005, but to no avail. Next para, learned counsel appearing for the respondents points out that the prayer made before this court is different from that made in the writ petition. So that apart, it is submitted that the appeal under section 11 is to be preferred before the concerned ministry, that is the Ministry of External Affairs, Union of India. Next para, it is seen from the array of parties that the Union of India through the Secretary, Ministry of External Affairs, as well as the Chief Passport Officer, CPV Division, Ministry of External Affairs have been implemented, respectively as respondent numbers 1 and 3 herein. In view of the innocuous nature of the prayer made by the petitioner while moving the writ petition, the court is of the opinion that the relief sought can be molded by passing appropriate direction on the appellate authority. Accordingly, WPA 17880 of 2023 is disposed of by directing the respondent numbers 1 and 3 for abundant caution. 1 and 3 to ensure that the challenge preferred by the petitioner under section 11 of the Passports Act, against the impoundment of the passport of the petitioner,
With section 5, my lord. Along with section 5.
along with application
5
for
application.
condonation of delay, as expeditiously as possible, preferably within 4 weeks from this date. If necessary, the concerned respondents shall give an opportunity to the petitioner to represent his case before the said authorities prior to the said decision being taken.
Grateful.
Thanks.
My lord, affidavit of service. My lord.
Affidavit service tried to get. Mr. Nandi, if please impress upon your clients if necessary, if you feel necessary, give him a hearing to predicate, I mean, future challenges again.
Very well, because that is the provisions of the statute.
I
also
think that
to-
is there.
Yes, it is there. Grateful.
21,
My lord, I appear for the state, your lordship.
For the state.
My lord, by Mr. Somnath Ganguly, my lord. Well, in 21, my lord, there are 3 private respondents, five private respondents. We have already served. 2 or 3 has not been received yet, my lord. So my lord keeps it out on Friday, my lord.
Friday it will be done within
My,
Friday.
my lord, we have already served them on 29th.
Friday, I have some difficulty.
On Monday, my lord.
Monday, then come on list. Learned counsel for the petitioner.
Tuesday, as my lord wishes.
No, Tuesday there are too many matters. Let it be in the common list. Learned counsel for the petitioner, in his unusual fairness, submits that service has not yet been effected on all the respondents. Full stop. Accordingly, on the prayer of the petitioner, let the matter stand adjourned and shall next be listed in the monthly list of August 2023.
Great.
Unusual to deven na. Yes, next.
22,
I am for the respondent bank.
Respondent, yes.
Lordship, I am for the petitioner. I am paying for not this fee.
Refused. Move the matter.
Yes.
Time is refused. Move the matter.
Thank you.
Yes.
Lordship, may I?
Happened to Mr. Chattopadhyay.
He went to the native village.
Yes.
Apparently, he has gone to the native place. Can I please continue? This matter is for home loan given by Canara Bank to this lady, and it is pending since 2005. The whole objection that has been raised here is how could the loan become 31 lakhs? Lordship, a 6 lakhs loan can become 1 crore also if it is left unattended and interest keeps on growing. Another major issue is that she has approached the writ court, whereas DRT is very much there for all her grievances.
Your learned friend will be embarrassed. Let us take it up on some other day when Mr. Chattopadhyay is there. When will he come?
Tomorrow he will come.
Learned counsel for the an adjournment is sought on the behalf of learned counsel for the petitioner. Learned counsel for the bank submits that the matter is on a small issue. Moreover, it is submitted that the writ petition is not maintainable in view of availability of equally efficacious alternative remedy before the debts recovery tribunal. Be that as it may, since the prayer for adjournment is made as a last chance to the petitioner, the matter is adjourned for the day and shall be listed next, fairly at the top of the list tomorrow. Fairly at the top of the list tomorrow as a last chance to the petitioner. Please convey to your learned friend, learned senior. Yes.
'23,
I beg to appear on behalf of state, my lord.
State,
I appear for the
licensee.
for CS Limited.
What?
My lord, admittedly, the petitioner before your lordship is a tenant.
Right.
My lord, eviction suit, page 12 onwards. And my lord, 151 application filed by the, my lord, dependent petitioner. My lord, kindly come to page 18 straightway. That order. 151 application filed on order passed on 22nd July 2022. My lord, I am not traveling your lordship. My lord, last portion, it appears from the documents annexed with the application of defendant that he is running a grocery shop.
You have been permitted to install electricity meter.
My lord.
Thereafter what happened?
Thereafter, my lord, I made an application, representation, but that was not considered by the, my lord, CSC, my lord.
What is the application for new
My lord,
connection?
page 29, my lord, docket number, district 28 and 29. And I,
Have you served on the private respondents, Mr. Chatterjee?
yes, my lord,
Check up.
private,
No, none of them are private respondents. I have ascertained.
my lord,
Your employee or entire family to check up whether.
Item delivered.
Yes.
Item delivered.
Involve your brother also, whether it has been delivered on
Involve.
the private respondents.
Item
I'm
delivered
interested in
address.
this.
Kuntol Saha, article receipt room. Item delivered.
Very well.
Item delivered. ঠিক আছে তো?
So why not being given, Mr. Bose?
My lord, we faced
Obstruction?
obstruction.
Learned counsel for the petitioner.
Initially, two facts. My lord, the instruction is here, kindly pardon. My
No,
lord,
no, we read that. Yes.
Initially, he applied for change of name. He was using a meter, which was in the name of the landlord. They were allowing. Now, this is landlord. Now, it is fight with the legal yes. So he prayed for change of name. That we processed.
Then what happened? Yes.
Thereafter, he abandoned it. He has not
Now he has applied for a new connection.
applied for a new connection, and in his own yes, and thereafter we carried out necessary inspection, but due to obstruction at site, it could not be complete, but we are ready to give it.
Learned counsel for the petitioner places reliance of an order passed under section 151 of the Code of Civil Procedure by the Civil Judge Junior Division 4th Court at Alipur in title suit number 1770 of 2019, which is an eviction suit instituted by the private respondents stroke landladies. Full stop. Next para. By virtue of the said order, the petitioner stroke tenant obtained an order whereby the petitioner's application was disposed of by permitting the defendant stroke petitioner to install electric meter in the suit shop room at the petitioner's cost. Full stop. Next para. It appears from the said order that the court recorded that the petitioner has been running grocery business from the main meter of the plaintiff's stroke private respondents in the premises in question, and as such is in settled possession of the property. Full stop. Next para. However, despite having applied for a fresh electricity connection, the petitioner has not yet got the same. Full stop. Next para. Learned counsel for the CSC Limited submits that the petitioner initially applied for change of name in the electricity meter of the private respondents. Full stop. However, the same was abandoned midway and the new application connection has now been made. Full stop. The CSC Limited does not have any objection to give the same, subject, however, to appropriate police help in view of obstruction raised by the private respondents and their agents. Full stop. Next para. It transpires from the order of the civil court annexed to the writ petition that the petitioner is prima facie in settled possession of the property. Full stop. Next para. Since an eviction suit has been instituted by the private respondents, the same is in any event, an admitted position. Full stop. Next para. Since the eviction suit is subsisting between the petitioner and the private respondents, there is no scope of observing that there is any ploy of splitting load by the petitioner by way of filing the new application. Full stop. Hence, there is no impediment in giving such connection to the petitioner, irrespective of any objection which might be raised by the private respondents. Full stop. Next para. Accordingly, WPA 17315 of 2023 is allowed, directing the CSC Limited to process the application for new connection made by the petitioner in respect of the premises in question expeditiously and, upon compliance of all formalities by the petitioner, to give such connection to the petitioner as expeditiously as possible, preferably within a fortnight from date and or from compliance of formalities, whichever is later. Full stop. If resisted, the CSC Limited personnel will be at liberty to approach respondent number 4, the officer in charge of the Patuli police station, who will act on a server copy of this order and give such assistance to the CSC personnel at the cost of the petitioner, to ensure that the CSC personnel have access to the existing meter board position for giving the new connection to the petitioner. Full stop, if need be, comma, the police personnel will be at liberty to remove any padlock or other hindrance for such purpose. Full stop, no order is to cause certain certified copies. It is made clear that the electricity connection, comma, if given, as and when given, comma, shall not prejudice the rights and contentions of the petitioner and or the private respondents in the pending suit between them. Yes.
One single sentence, in view of the direction for providing new metered supply, his application, which is still pending, made on 19th.
No, you said they're not, they've abandoned.
Online, that will stand.
That is not the subject matter of this, Mr. Bose. I won't pass an order.
Instruction on behalf of the state may kindly be kept.
The written instruction filed by the state be kept under.
That should
No, Mr.
stand
Bose, not on
abandoned.
that, no. No. Change of name you reject if it is still pending. You said they abandoned midway. I recorded
Yes,
that.
we have raised the bill, he has not paid.
Then reject. Why should I pass an order, put it in my order? This does not automatically mean that.
As you lordship. As you lordship. Deep look.
24.
For the petitioner.
Yes, Mr. Bhattacharya. Right.
Led by Mr. Ansar Mondur.
You are on the panel now?
Yes, my lord.
Very good. Now don't pray for time on the ground
No,
of
my lord.
anybody. Not in this matter, in other matters also. Remember that. Yes. Yes, Mr. Bhattacharya.
My lord, what happened, my lord, the petitioner and the private respondents are co-sharers.
Served.
Served.
Yes.
Object.
Yes.
Co-sharers. Now, my lord, what happened, my lord, there is a pond, water body. Now, my lord, they are raising construction, my lord, by, my lord, turning it into a solid land. My lord, we have made several representations, my lord,
Without
nothing,
formal conversion.
without formal conversion. My lord, section 17 of
So this is a
West Bengal,
considered representation application.
West Bengal section 17 of the Inland Fisheries Act.
Which authority should look into it?
My lord, the SDO Shodor.
3.
3. SDO Alipur.
Yes, what do you say?
My lord, it's a purely civil dispute. My lord, kindly see the
Conversion is not a civil dispute.
it's a problem, my lord, between the Doba and the Pukur, my lord. Kindly see. My lord, it will be looked into by two authorities. First, my lord, the subdivisional
kindly see
officer
the
is the
instruction.
authority under the Inland Fisheries Act, and 4C, 4D of the Land Reforms Act. I have also made Block Land and Land Reforms Officer also.
I'll record a submission, but direct. Learned counsel for the petitioner argues that the petitioner has specifically alleged against the private respondents that they are trying to convert a pond without formal permission of the appropriate authorities, comma, including the fisheries department as well as the block land and land development officer.
Reforms Officer.
Pardon?
And Reforms Officer. Not
Block land and land reforms officer.
And my lord, another thing, my lord, in the LR record, it is recorded as Pukur and Doba.
Full stop, next para. It is further submitted that in the LR records, comma, the property is recorded as Pukur and Doba. Full stop, next para. Being aggrieved by such inaction of the authorities, comma, the present writ petition has been filed. Full stop, next para. Learned counsel appearing for the state files a report which is kept on record and contends that the dispute in question is primarily a civil dispute between the parties. Full stop, next para. However, comma, the grievances raised by the petitioner are required to be decided by the appropriate authorities, comma, since they are not restricted to a civil dispute of a private nature between the parties, but also pertain to violations of several statutes, including the West Bengal Land Reforms Act, as well as what is the other act?
West Bengal Inland Fisheries Act.
The West Bengal, as well as the West Bengal Inland Fisheries Act. Full stop, next para. Hence, comma, the grievances, the complaints lodged by the petitioner are required to be looked into and inquired. Full stop, if necessary, comma, appropriate steps are also required to be taken thereon. Full stop, accordingly, WPA 17347 of 2023 is disposed of by directing the 3 and 4.
My lord, 3, my lord, is the
Which two authorities are to be directed?
3 and my lord, 7 is the Block Land and Reforms Officer.
By directing respondent numbers 3 and 7 to consider the representations annexed to the writ petition and addressed to them as expeditiously as possible, comma, upon holding an appropriate inquiry in that regard, comma, if necessary, upon giving opportunity to the petitioner and the private respondents to ventilate their version before the said authorities. Such exercise shall be completed as expeditiously as possible, comma, positively within 6 weeks from this date. Upon such inquiry being concluded, comma, if the said authorities are of the opinion that there is a contravention of any provision of law by conversion of the water body into some other nature, comma, immediate steps shall be taken by the said authorities in that regard in accordance with law. The report filed to be kept on record. No arrest to cause urgency.
Great.
Yes.
25.
I'm for the state in this matter.
I'm for the second appeal authority, Mr. Shah Lordship.
I beg to appeal for respondent number 2, Lordship.
Again, RTI Act, yes, but
My lord,
whatever is your allegation, Mr. Bosumullik is responsible for this.
my lord, I have done nothing.
Please take the microphone a bit, please.
My lord, the petitioner advocate Dev Kumar Maiti, due to illness, come to court. For that reason, paid not this week, my lord.
What is the prayer? You are not at all in the matter.
No.
A prayer for adjournment is made. Let the matter stand adjourned and shall next be listed in the monthly list of August.
For which I am not responsible.
For this you are not, definitely.
Grateful.
Thank you. Yes.
Sorry about
যারা যারা ছিল শুধু তাদের নাম রেকর্ড হবে। Yes, next question.
26.
26, my lord, the advocate for the petitioner is suffering from an eye infection, my lord.
Not personal ground. An adjournment is sought on behalf of the petitioner. Let the matter stand adjourned and shall next be listed in the next monthly list. Next month, next week.
27.
Well, I'm for the petitioner, but service is not completed, madam. The private respondent.
Private respondent who is appearing for the private. Mr. Bihani, you are appearing for
No, proposal.
I
am for the pollution control board.
You appear for the private respondent as well.
Very
The private respondent is necessary
Because it to be regularized.
because I've taken some order.
Learned counsel for the petitioner submits that the private respondents have not yet been served properly. Let them stop. Accordingly, let the matter stand adjourned till the monthly list of August.
Good.
The report filed by state.
State কোন মামলা 27
State আছে তো party.
State. Who is for the state? You also have a report. I'll take both the reports on record.
I'm sorry, my lord, I'm 28.
You can also file a report. You can file the report of the center also. Very well. The report filed by the state today be kept on record.
But my engagement is not regularized.
Oh no, definitely.
Lords.
On the next occasion, yes. Yes, call on next.
28.
Yes,
28, my lord, I beg to appear for the petition, safety for service, my lord.
All have been served, probably.
Yes, my lord. The second round of litigation, my lord. Your lordship, this is regarding that Durga Puja at NKDA.
Yes.
Your lordship was pleased to direct the authority to consider my representation.
Yes.
The representation was considered and rejected on an absolute irrelevant grounds, stating that this is a populated place, traffic disruption will be there, and on other grounds. My lord, the particular place is a Mela ground. Every year, several melas like Shabola Mela, Sharosh Mela, different book fairs, different programs are regularly being organized over there.
Yes.
I'm not asking the place for free. I'm ready to pay whatever charges are there for the particular place. And another puja, kindly consider, I have made the application long back in March. Until July, it was kept pending. And in the month of July, after order passed by your lordship, NKDA is coming with the rescission order and stating that is a, kindly sees the order, my lord, kindly comes to page number 42, page number 41. Reasons.
Yes.
Decision with reasons, my lord. Second paragraph, whereas the NKDA do not have exact.
Chaudhary is appearing for the DT.
I'm for the DT. I want to come and be consecrated over there.
Yes.
Whereas NKDA do not have exact population figure of the present status of the residents of Newtown, 36 residents welfare association and block association are already celebrating Durga Puja of various size, exclusively initiated and organized by the resident of the resident welfare association of the block of Newtown. But these are different places, quite normal during puja. But I am asking the question to myself whether any other permission has been given to NKD for that particular Mela ground or not. These are in other places the puja are being organized. Second, my lord, whereas it appears that in the year 2022, Newtown Sarbojain Durgotsav, and that is a special Durgotsav I don't like to mention, my lord. This is organized by very influential person and person who is associated with HITCO. They are getting permission, they are getting everything, and every year I have to knock the door of this court to get the permission, even after I'm ready to pay the charges. It's not I am praying for any mercy that give us the land for a particular place for free. Second, my lord, this was celebrated at the city square, located at the heart of the action area, whereas resident from the whole new town is participating in this puja. Notably, the city square is not a residential zone. But kindly consider, city square is just before the central mall, and just beside that, Shankolpo and other residential areas are there. And just beside that, one old age home, namely Snehodia, is also there. They are giving permission over the particular that place, stating that it will not affect anyone. And whereas Newtown Mela Prangon is almost isolated area, situated at the juncture of Bishwangla Gate, and that just one side, and that is not that populated area. There's no residents are there. There are some hotels. Admittedly, there are some hotels. Next paragraph, Mano, next page. 42.
Yes.
The petitioner Manav Jati Kollan Foundation is, however, a corporate entity, not a residence group. In any event, the location of action area such and such demanded by them as their venue is within 800 meters within the city square, where already Newtown Sarbojain Durgotsav Samiti has been holding large celebration of Durga Puja, which is expected to attract a big football. Well, I'm asking the question to myself, can it be a ground, my lord? Last year, I have organized a puja on that particular place with the permission.
In this place, I mean, where you were asking?
Asking right this year. And this is not the case that there is something due. I have given all the money. Not a single paisa is due towards anyone. Not an untoward incident happened over the particular place.
Previous year you did the puja with court's order?
Yes, my lord.
All right. Very good.
Then, my lord, next paragraph. As already indicated, there is a dense residential locality on the periphery of the desired location, and mass petition in writing have already been received from the residents that noise, sound pollution, other crowd have been disturbing them. But I am asking question to myself whether any complaint was raised before the pollution control board or not, before the last year's puja. And I am very consciously saying, as I am resident of that particular area, that area is isolated area, whereas Times Square, the city square, which is in where Andhra Puja is being organized, that is most popular area, situated in front of a mall of Newtown. Residential areas are there, old age homes are there, and that place is allowed because some influential persons are there. And this place, even after this isolated area, every year I have to come before the court, knock the door of justice, seeking permission.
You are also influential, but not influential with these authorities. So your influence is elsewhere.
Next issue was, next reason of rejection was something more.
So one of the grounds is residential, another is another big puja.
Big puja, and third ground is from ROC, company master that is found, registered address of Manav Jati Kollan Foundation is such and such. Admittedly, registered address is that. Admittedly, sister concern of Manav Jati Kollan Foundation, namely Newtown Intellectuals, they are organizing the puja. I'm asking the question to myself whether this can be a ground for rejections, my lord, without application of mind, without thinking over it and sitting tight over it from the month of March at this juncture when I've made the advance to every authority, I've made payment, and now they're coming and saying all these things, my lord.
So yes, what is your answer to this?
Well, the NKDA is the probably
you're for the state
respondent.
Oh, you're
for NKDA and HITCO.
Very well, yes. What is your
real Lord opponent for this? Firstly, last year I came and conceded, got into a lot of trouble for that. But Lord, we agreed to give them Lord some place which is in the vicinity, not where they want right now. So, my lord, last time, my lord, they had come just before the pujas, if I'm not wrong.
Yes.
So we had agreed. My lord, they came on, my lord, 13th of July. Oh, this is the last one. No, they'd come just before the puja. Now, my lord, what is happening is pujas are essentially allowed in the park in every block, and, my lord, in every high-rise building, and in certain other places which we have designated. Beyond this, we, my lord, don't give. And the reasons are traffic congestion, difficulty in managing movement. Now the petitioner might say that this is a mala prangan. Why will you not give it over here? That is something, my lord, we'll have to justify before your lordship. Whether, my lord, a citizen has a right to organize a public pujo in a planned city, in an area designated for a mala, is, my lord, one question. And secondly,
The mela ground, why not? I mean,
so that is, my lord, they say
one can hold a mela, why not a puja? I mean,
can't be footfall, can't be, my lord, I'm saying can't be footfall spoiling the ground.
Unless the mela ground is allergic to flowers and offerings.
No, it is not that. Only reason is what I find is there is already enormous congestion in the nearby areas because of the number of pujas, and traffic is a problem. Number of people is a problem. Secondly, this is a planned city. This is certain things are meant for. Otherwise, from tomorrow you'll find people doing puja on the road.
They offered namaz a few days back, madam. That was allowed.
And whether petitioner can.
They offered namaz in Newtown.
That particular mela prangan.
They did.
It was given.
They've annexed something.
No, madam. I didn't annex what I.
Very well. You can annex something if permitted.
Yes, madam.
Yes.
Lord, may I come back in 7 days' time with an affidavit? No, you're thankfully you're still in July, end of July. So if I will diligently, my lord, within 7 days file the affidavit, the lordship decides the question, my lord. Because I'll also say that the petitioner who's from Nodia, whether, my lord, he's entitled to suddenly select Newtown as his place of worship. But why not get blessings from Lord God in Nodia?
That ground, can you, Mr. Chaudhary, can you?
Can I today, my lord? I'm
He's
sorry.
a citizen of India. Wherever he resides, he can seek to do that. If he takes the trouble of coming from Kollani to this place and do
And
the puja.
perform a public puja.
Public puja, even then, that's easier than a private puja nowadays.
That's actually
Seen, does not require to be present or personally all the time. One person.
correct.
If it was a private puja, it could be more suspect.
It is more strenuous also, my lord.
Obviously, yes.
Yes.
3 days for reply.
Affidavit, let him come
I'll
argue
put
it
it fairly at the top of the list because
and decide, my lord, this.
yes.
This is
Less than 100 days are left, madam.
yes, so 7 days.
Yes,
I
that's
have
why
been
it's top
given,
of
my
the
lord,
list. Yes.
that, my lord, recognizing my learned friend's urgency,
7 weeks is very fair.
7 days. my lord.
7 days. Learned counsel for the petitioner raises a question as to the impugned refusal to the petitioner to hold a Durga Puja festival. Full stop, next para. Several grounds are sought to be made out. Full stop, however, learned counsel appearing for the respondent authority seeks to use a short affidavit to controvert the allegations made in the writ petition. Full stop, accordingly, the respondents are directed to file their affidavit within 7 days. Full stop, reply, if any, shall be filed within 3 days thereafter. The matter shall be listed fairly at the top of the list for hearing on 14th August. On August 14th, then. Fairly.
No.
If you are in difficulty?
Yes.
August 14th.
No, my lord, please.
Any day other than 14.
Why you are so impatient for a puja? You are an intellectual in Newton also.
In August, I will not be here, madam.
Any day other than 14, my lord, any day, my lord.
On August 17, 2023. 17th August.
Grateful,
One day after that 3-day period.
Yes. Grateful.
Grateful, my lord.
Fairly at the top, একটু উপর দিকে করে দিও দুর্গা পূজা অভিশাপ খেয়ে যাবে দেন।
29.
I am for the petition, lordship.
Yes, Mr. Haldar.
Lordship, this is my affidavit.
My lord, Mr. Shankar Bhattacharya.
Anything apart from time? Use the microphone.
Mr. Uday Shankar Bhattacharya is appearing in CSC Limited. C is on Lakes Court.
Anything except for time. Yes, move the matter.
Lordship, petitioner is a tenant, Lordship, applied for domestic.
You are for the respondent, private respondent. Why are you opposing, landlord?
But I am not opposing. 12 to 13 electric connections are already there in the premises, my lord. There is
Then
a
they are
question.
necessary.
Lordship, kindly
So what is
tomorrow at the top of the list, Lordship.
An
without
adjournment is
electricity.
sought by the distribution licensee. Full the affidavit of service filed today be kept on record. Full in view of such prayer for adjournment, the matter is matter shall be listed tomorrow, fairly at the top of the list.
Grateful.
Top of the list বেশি থাকবে কোনো অসুবিধা নেই এগুলো আগে ওপ করে দিন
30.
I am for the petitioner.
I'm for the electricity company.
Lordship, petitioner applied for
Who is for the landlord? Yes.
No, no, application for connection for submersible pump, Lordship. Applied and Lordship, the SCDCL authority accepted, but till today they have not taken any steps.
Why not?
My lord, we had undergone an inspection, my lord,
Yes.
on 22nd of June, my lord, and it was observed that the meter room was not ready and the earthing and the wiring was also not ready. We had given them a letter to that effect, and we have urged them, requested them to supply the infrastructure as well as the GST bill and the horsepower, my lord, along with the serial number of the pump within 7 days, my lord. And my lord, on 3rd of
Got a copy of that letter?
Yes, my lord, I have a copy.
Then
of
what happened after that?
My lord, they haven't replied on that letter, my lord.
7 days have elapsed.
Yes, my lord. This is the copy of the letter, my lord. And on 3rd of July, my lord, we had also given them another letter requiring them to submit the certificate of registration. My lord, even that letter is also.
Yes, Mr. Halde, you are suppressing this in your.
My instruction is that we have not received any letters, but Lordship, we are ready to comply with the formalities.
Should I dispose of?
Lordship.
The petitioner is aggrieved by alleged inaction by the WBSCDCL on an application for new connection to operate the petitioner's submersible pump. Full stop next para, learned counsel for the WBSCDCL hands over copies of 2 communications dated June 23, 2023 and July 3, 2023 made by the WBSCDCL to the petitioner seeking certain further information stroke documents to enable the WBSCDCL to ascertain feasibility of giving such connection. Full stop next para, learned counsel for the petitioner submits that the petitioner is agreeable to comply with such formalities. Full stop. Accordingly, WPA 17788 of 2023 is disposed of by directing the petitioner to furnish the documents, as sought by the WBSCDCL to the respondent authorities within a week from date. Full stop. Upon such documents and information being furnished by the petitioner, the WBSCDCL shall give a new electricity connection to the petitioner, subject to compliance of all other formalities as required by law, within a fortnight from compliance of such formalities by the petitioner. Full stop. Have you handed over copies of this today?
No, my lord, I don't have extra copy. I'll give it to him throughout the day, my lord.
During the course of the day, you
Yes,
can?
my lord, I'll give it to him.
The Artaline Adkoda, the learned advocate for the WBSCDCL shall hand over the copies of the document handed over and kept on record to his counterpart appearing for the petitioner during the course of the day to enable the petitioner to comply with such formalities.
Grateful, my lord.
It is record.
31.
My lord, I am applying for the licensing. Your
Yes.
lordship, I am for the petitioner. Your lordship, this is the affidavit of
Please use the mic.
affidavit of service. Your lordship.
Yes. What is the grievance?
Your lordship, I'm praying to supply the electricity connection, your lordship, by installation of a new meter. I have made several representation.
Have you applied formally or only representations?
Your lordship, I have applied.
Where is the application? Not annexed.
Your lordship,
Probably you have not applied, only made representations. Yes, what is your standing?
My lord, in this matter, object that is the
Can't
object written objection is raised by the landowner, my lord, and whereas he's not a party in the.
Can you give the details of the landowner to her so that she can plead? একটা order record. Learned counsel for the petitioner submits that despite having applied for a new electricity connection, the WBSCDCL has not given the same. Full stop. Learned counsel for the WBSCDCL submits on instruction that the landowner
your
that the
lordship, I'm the lawful landowner. Your
That the
lordship has-
alleged landowner has given an objection to such connection being given. Full stop, next para. The petitioner controverts such submission and argues that the petitioner is the landowner. Full stop, next para. However, comma, since a specific objection has been raised by a third party, comma, who has not been implemented herein, comma, the ends of justice demand that the objector is also implemented for ventilating his stroke her case before this court prior to deciding the writ petition finally. Full stop. Accordingly, the petitioner shall implead the objector, comma, particulars of whom shall be found.
My lord, this is the objection letter, my lord, written objection, my lord.
Particulars of whom shall be furnished by the learned advocate for the WBSCDCL to the petitioner during the course of the day, comma, full stop. Necessary consequential amendment to the cause title of the writ petition shall be carried out by the learned advocate on record for the petition. You are the advocate on record.
Your lordship.
Is your advocate on record in court?
Well,
By the learned advocate on record for the petitioner by tomorrow.
By
Full stop. Next para. A copy of the writ petition shall be served on the added respondent expeditiously, indicating that the matter shall next be listed on August 16, 2023, when the petitioner shall file a fresh affidavit of service regarding service having been effected on the added respondent. Full stop. Does this much? Have you got a copy of this?
No,
Please copy the address and the name of the objector and hand back to the court immediately.
16th August.
16th August, yes. Eight recorded. Only the affidavit of service filed today be kept. No. Yes. ওটা একটু অরিত্র ফেরত নিয়ে নি।
Original site date list, restoration application, item number 1.
I appear for the respondent. I would take the point of maintainability. Writ petition is not maintainable.
Restoration application. Oh, that matter. Yes.
My lord,
I am for the petitioner. This is for restoration of the writ petition.
Yes, my lord. Restoration, I have nothing to say. But
Obviously.
writ petition is not maintainable.
Mr. Manager, allow the restoration application immediately.
Yes.
Immediately hearing. Yes. In view of sufficient reason for the absence of the petitioner on the relevant date and the delay in filing the restoration application having been made out, comma, GA1 of 2023 is allowed, comma, thereby condoning the delay in filing GA2 of 2023, full stop, on the same grounds, comma, GA2 of 2023 is also allowed, comma, thereby restoring the writ petition, that is
notification ta koi
WPO number 564 of 2023 to its original file and number. Full stop, next para. The writ petition is taken up for hearing as a motion, full stop. At the outset, comma, learned counsel for the, you are for which respondent, Mr. Banerjee?
My lord, I am for respondent.
For respondent number such and such, raises an objection as to maintainability of the writ petition. Full stop. এটা কন্টিনিউ করছি তারপর এই পর্যন্ত থাক হ্যাঁ
But I am for 1, my lord. NCLT, my lord.
রেসপন্ডেন্ট নাম্বার 1 হ্যাঁ যেটা বললাম
হয়েছে?
আর বাকিটা আমি বলে দিচ্ছি yes what is the objection Mr.
My lord,
Banerjee?
his claim, this is now settled law, my lord. His claim is around 50 lakhs of rupees.
Right.
Now, my lord, there was a notification which was passed by the after the, my lord, Union of India, by which, my lord, the threshold limit for filing proceedings before the NCLT has been enhanced to 1 crore. Now, all those matters which are below 1 crore are being dismissed with the liberty, as has been given. My lord, Lordship will kindly take the impugned order, which is at the last annexure. Lordship will find it stated, my lord, in this matter, the amount claim in default is 24 lakhs and odd, along with interest outstanding 27 lakhs, aggregating 51 lakhs. Now, my lord, kindly sees thereafter. Therefore, in terms of order,
which page, Mr. Banerjee?
This is the last annexure, my lord.
My
This
lord,
shouldn't be paginated because
my lord,
last annexure of a writ petition. My lord.
Volume 2, my lord,
Oh, yes,
after
yes,
page
sorry.
291.
Yes, volume 2, my lord.
Yes, yes.
My lord, in this matter, the amount is in default is 24 lakhs and odd, with interest 27 lakhs and odd, aggregating to 51 lakhs and odd, which is below the threshold limit of rupees 1 crore specified in section 4 as amended by 24/3/2020. The application was filed before this court on 3rd of January 2021, which is after the date on which the threshold limit was revised to rupees 1 crore after 24/3/2020. So the act has been amended. Now, my lord, therefore, in terms of the order of such and such passed by the NCLAT, this petition is not maintainable and dismissed as infructuous. But there is a liberty given by liberty is granted to the operational creditor to file appropriate application for revival of a company petition in the case of civil appeal by Jumbo Paper Private Limited versus Hansraj. Now, this judgment I've got a copy, my lord, which says, my lord, if it is allowed, then he can again file. Otherwise, there is an amendment to the act. He cannot. It's not maintainable.
What is that challenge? Civil appeal?
My lord, this is the civil appeal.
Yes.
I'll give a copy to my lord. This is, my lord, the NCLAT order, which he has not enclosed. This is the NCLAT order, and from that they had made an appeal. The appeal is pending. There is no stay whatsoever. So what NCLT is doing, my lord, is it's passing an order with a liberty with all applicants, my lord, that if in Supreme Court ultimately it is, my lord, turned down, then you will have your right to come before and
the revival of this company petition subject to
yes. So he will not be, my lord, suffering the limitation part. That is a liberty given. So it's not maintainable. As of today, it is not maintainable.
So rightly rejected.
My lord, myself question, my lord, if there has been, my lord, liberty, if there has been any application pending before your lord,
liberty need not be given by him also.
My lord, yes, my lord. My lord,
Any
the
event
application will be, my lord, signed or my lord kept in pending, my lord, but my lord, the threshold, my lord, it was, my lord.
So Shashmali, you are not clear on this. He could have rejected outright without any liberty.
Yes.
Because as of today, as of the date when this order was passed, it was not maintainable. So he could have rejected, he or she, they could have rejected outright.
Yes, my lord, outright they are rejected.
So rather they have given you a liberty which is being very condescending in the circumstances.
But my lord, in my lord, order dated, my lord, of London NCLT, there are two content. My lord, first, my lord, threshold, my lord, dismiss the application. Thereafter, my lord, give the liberty. If my lord,
well, if you ask, I can set aside the liberty portion, the dismissal remains. I set aside the liberty, the dismissal remains. If you are agreed with two components of the order.
My lord, at least, my lord, give the petitioner, my lord, liberty to file, my lord, difference for my lord, there have my lord, commercial, my lord, bench, my lord.
That he can always do. That he can always
my lord,
do.
Here, my lord, one application has been, my lord, there have a liberty.
In fact, my lord, his proceedings, if he challenges this order, let us take, my lord, there was no 4 crores and 1 crore and all. His challenge has to be under section 61 of the my lord, IBC. It's not at all maintainable here. And secondly, this is now settled law, my lord, because of this matter and the amendment to the act.
Learned counsel, ওটাই continue করুন, পরের paragraph থেকে. It is contended by learned counsel for the petitioner that the present writ petition is not maintainable in view of the nature of the impugned order. Full stop, next para. Learned counsel places the impugned order which records that in view of the threshold limit of the National Company Law Tribunal within bracket NCLT having been revised to rupees 1 crore on and from March 24, 2020, and since the application was filed on January 3, 2021, that is, thereafter, and the claim on which the application was filed was much below rupees 1 crore, the application was to be turned down at the threshold. Full stop, next para. It is further pointed out that in the same impugned order, liberty has been granted to the operational creditor stroke petitioner to file an appropriate application for revival of the company petition in case a pending civil appeal before the Supreme Court against the NCLAT order on such court succeeds. Full stop, next para. In any event, it is contended that a challenge against the impugned order would lie under normal circumstances before a different forum under section 61 of the Insolvency and Bankruptcy Code 2016. Full stop, next para. Learned counsel appearing for the respondent number 1 also places reliance on a copy of the NCLT order, which has been referred to in the impugned order.
Only one thing, the notification is also on record, my lord, I believe. It is there, my lord, I think. Yes.
Very good.
Yet, please.
As well as as well as the concerned notification dated March 24, 2020. So next para. Heard learned counsel for the parties. Full stop, next para. The respondent number 1 is justified in arguing that the threshold limit for entertaining an application by the NCLT was raised to rupees 1 crore. Full stop. The concerned notification dated March 24, 2020, being notification Vide SO number 1205 within bracket E bracket closed, indicates that in exercise of the powers conferred by the proviso to section 4 of the IBC, the central government specifies 1 crore rupees as the minimum amount of default for the purposes of the said section. Full stop, next para. In the case at hand, the petitioner made a claim of rupees 24,02,150 along with interest to the tune of rupees 27,44,541, aggregating to rupees 51,46,691, which is undoubtedly much below the threshold limit of the NCLT. As such, the rejection by the NCLT on the ground of lack of inherent pecuniary jurisdiction was justified. Next para. In fact, the NCLT was gracious enough to grant liberty to the petitioner operational creditor to file an appropriate application for revival of the concerned company petition in case a pending civil appeal before the Supreme Court was allowed. Next para. On such score as well, a perusal of the order passed by the NCLT Limited endorses the stand taken by the NCLT. Moreover, since a liberty has, in any event, been given to the petitioner on the pending appeal before the Supreme Court against such order of the NCLT succeeding, there is no scope of interference in the present writ petition at all. Accordingly, WPO number 564 of 2023 is dismissed as not maintainable. However, it is made clear that the liberty granted in the impugned order by the NCLT remains. No rest to cause urgency.
Grateful, deeply.
Court application, item number 3.
Number 1.
File
1453.
Yes, what is this? 3?
This is affidavit of service. On this identical issue, there are 3 petitions pending in the appellate side also. There is an order in also, the issue is this. Non-supplying the certified copy by the court below.
Pura tagged হয়ে গেছে অন্যগুলো কি tagged হয়েছে এখানে? Yes, those are to be tagged with this also.
I think that should be there are 3
Or can I
on the same identical issue. One.
Item 4 is also same.
No, that is different. That is
Different. 3 and 4 already.
There are
3 and 4 দুটি বোর্ডে দেখা যাচ্ছে।
Even the order below, that is saying that is not same.
Not same. Let us hear 3 and 4, then we'll decide. Yes.
There are 3 petitions pending for the appellate side that should be tagged with this because the identical issue and that is observation of the coordinate bench regarding their pending petition.
They were directed to appear together, Mr.
No, I beg to differ. Lordship, kindly see the prayer he has made, and these two matters are completely different.
So that
He has asked for a particular certified copy. For non-supplying of the certified copy, he has preferred this writ. I have taken the specific instruction initially, Milord, there is some technical issues for non-supplying of the Milord. It has been sorted out. We have Milord asked the Milord the petitioners to go over there and put the Milord signature, and he'll be getting back within the 7 days. That is what I am.
Which forum? Which authority?
Milord, this is the CMM, Bankshal Court, Milord.
Let us dispose of this repetition, get the certificate.
The point is the issue is a recurring in nature. In last 5 years, there are three or four petitions pending. Whenever the petition is filing, that is giving the copy. Otherwise, not.
No, cite the order passed in these writ petitions, Mr. Datta. Cite the order passed in this writ petition in the appellate side matters when those are taken up. Why club it?
All right.
I'll dispose of this writ petition.
The point is this. My prayer is this. As per the criminal rules and orders of the High Court, there is a specific provision. What is the procedure has to be followed?
Yes. Yes.
Kindly see the provision of the 260. There is
No,
whenever an application has to be made, the head company is duty bound to mention in the counter slip the next date of assessment and everything. Step by step, the procedure has been followed, but they are not following this. My prayer is this in the petition.
What are they doing?
They are doing the simply kept in the matter month after month. Month after month, there is no limit. When they will give the copy, there is no time limit.
But then you have to file a public interest litigation, Mr. Datta.
It's a larger scope.
It can be converted into, because as per the rulings of the notification, your lordship can
Milord,
remit the matter to the division bench for taking up the
Milord,
matter as a public. Yes, that's
this particular matter pertinent to one particular matter.
Mr. Datta, the difficulty is if this is converted to a public interest litigation, you will not get a remedy there because you have not put in the other fact, some other matters also. It has to be shown in a public interest litigation that this is being generally done by them. At least some other instances have to be given.
Just to particular this matter to remit the division bench, I will mention
This matter I'll dispose of. I'll give you liberty to approach the division bench with a public interest litigation also.
If your lordship desire it, it is a public interest litigation.
Do you want a relief in this writ petition? Then I'll grant that writ petition. If you don't press this writ petition, I'll let you file a public interest.
Lordship has the power because as per notification, the
Public interest litigation.
your lordship has the authority. Kindly see the monthly list. Kindly see the monthly list.
Whatever is written in the monthly list.
Yeah, month that is the notification.
There will be a public interest litigation filed against that then.
One single.
If I assume jurisdiction, there will be a public interest litigation against that.
When a single bench entertaining a writ petition, find it that the matter involved in the public interest litigation, the bench can refer the matter on the CBSE.
No, I don't find it from these.
Yes, it is
These
not
big
there.
allegations, Mr. Datta, frankly speaking, I don't find it has any public interest.
Decided. Then it has to be decided by your lordship.
I'm allowing this writ petition. They're agreeing to give you a certified copy. You are not agreeing to that.
What I problem is this that should be a modality because they are not following the rule. That should be a
একটা order record করুন ওনাকে বলে। Mr. Datta, you're out.
I am getting out all time.
No, not all. Once you scored a century in my in a very bad matter that too. Otherwise, you were generally middle stamp. But this is a good case otherwise because they've considered also. Learned counsel in both the writ petitions submits that the petition they're not
one by one. Lordship kindly takes it up one by one. This is the
you're not agreeing in the other one.
No, this is something different. The prayer is different.
Achha, then I'm taking up which one? WPO?
This is
5-3.
1-4-5-3. Yes.
Achha.
One by one. This different.
Very well. Learned counsel for the petitioner contends that the petitioner, comma, despite having applied long back, comma, is not getting a certified copy of an order. Full stop. Learned counsel places reliance on the relevant provisions under rules 261, 262, as well as 265 of the criminal rules and orders framed by this court, comma, and argues that it is the incumbent duty of the respondents to allot a specific date for assessment of the necessary stamp duty and the subsequent schedule for the purpose of issuance of certified copies. Full stop. However, comma, it is contended that as a general malady, comma, the present respondents are not following such procedure in any of the certified copy applications. Full stop. As such, comma, it is argued that the respondents be directed to issue the certified copies of the petitioner. Full stop. It is also hinted by learned counsel for the petitioner that the present writ petition has an element of public interest litigation, since the respondents are, in general, adopting the mode which has been challenged in the present writ petition. Full stop, next para. Learned counsel appearing for the which respondent? Number 3.
Milord, I am appearing, Milord, 3, 4, 5, as well as the respondent number 1.
Number?
Respondent 1, 3, 4, 5.
Learned counsel appearing for respondent numbers 1, 3, 4, and 5 submits that although there were certain initial glitches, the respondents are ready to hand over the certified copy of the order as sought by the petitioner, subject to the petitioner putting in certain necessary signatures. Full stop, next para. In view of the stand taken by the respondent authorities, there is no need to keep the present writ petition pending. Full stop, next para. However, if the petitioner is aggrieved by a general inaction on the part of the respondents, it is always open to the petitioner to move the appropriate division bench headed over by the Chief Justice, by furnishing full particulars of the general nature of inaction of the respondents, by way of a public interest litigation. Full stop. If such a litigation is filed, the same can be decided in accordance with law by the appropriate bench. Full stop, next para. However, a perusal of the present writ petition indicates that there is no element of public law or public interest involved in the present writ petition. Full stop, next para. In such view of the matter, WPO 1453 of 2023 is disposed of by directing the respondent numbers 2 to 4 to ensure that, 3 and 4.
It will be 5.
3 to 5.
Yes.
To ensure that the certified copy as applied for by the petitioner is handed over to the petitioner within a week from the petitioner putting in the requisite signature, the requisite signature
and the fees. Signature and the fees.
And putting in the requisite fees. Full stop, next para. No order as to cost at the certificate copy. Yes, what about the next one?
Item number 4.
Thank you.
Next one, my lord, this is the
It
order passed by the court below, civil court and criminal court. Their order is not available in the e-court service.
Order is not available in?
The e-court service. The high court side that is available, but in the court below, civil court and criminal
on
court.
on their portal it is not available. On their, they have a portal.
Yes, e-court
District courts portal and e-courts. It is not available.
Yes.
The same order for which you applied for certificate copy in the other matter. It's a different matter.
It's a general omnibus prayer has been made. Lordship, kindly see page 5 once. Page 5.
Let him complete. Yes.
Your lordship's previous order is there. Kindly come to page number 5.
Yes. What did I do?
I am also relying the page number 5.
This was passed in this order.
No, this is another matter.
So that matter, what happened to that matter?
That is kept pending.
That is the appellate side matter.
Yes, that is
Have you filed a report there?
No, I have not appeared. Mr. Learned Advocate General has appeared. Either it has to be tagged together, Milord, in order to Milord. I think
this should be tagged with
yes,
the
yes.
Right.
No, I have seen that. This I said so. Yes.
They ensure that
prayer is, my lord, this is absolutely.
Yes, Mr. Datta, I was overactive on the last August. This is a public interest litigation.
Absolutely.
Pure public interest.
Kindly allow one day time. I'll satisfy your lordships can refer the matter to the division. One day time. I'm just.
Should I refer this matter? I can immediately refer.
That your lordship always.
You don't have sufficient details here. You are on a general footing, Mr. Dotto. Your prayer is direct the respondent authorities, particularly such and such respondent, to ensure that daily order is uploaded by all civil and criminal courts. Definitely, you may have a grievance that why not? But here, your entire cause of action, your pleadings is your petitioner is a law clerk, respondents are statutory authorities, and in respect of your matters.
No, litigants.
My lawyer filed a writ petition being such and such, which was not uploaded. That cannot be the premise for this prayer. So if you want, I can very well refer this. But the next day, the Chief Justice will say that file a proper pleading or reject this, which will be easier for the division bench.
Your Lordship refer the matter, you do not want to entertain, then
Very
whatever decision will be taken by the division bench, that will be taken in.
Very well. The prayer made in the present writ petition is of an omnibus nature. First of the petitioner has sought a direction on the respondent authorities, particularly the respondent number 3, that is the High Court at Calcutta, to ensure that daily order is uploaded by all civil and criminal courts in all matters in the e-court services within bracket server of e-court bracket closed to apprise the same to the petitioner, including to all concerned. Full stop, next para. Since there is an ingredient of a public interest litigation. No, I will not relegate you to a public interest litigation. Mr. Bhattacharya, I will not relegate him to a public interest. Let the registrar file a report. I mean, this is the High Court. I was thinking this is also City Civil Court. Our own court, we should be cautious on this.
He has made that is it is up to your Lordship. I cannot stand in there. It will benefit.
No, otherwise everybody would be benefited.
একটা line record.
Everybody will be benefited in spite
although
of opposing it.
They are not opposing it.
No, it continue. Since there is an ingredient of a public interest litigation, এটাকে শুরু করেছেন since দিয়ে. Ingredient of public interest litigation in the prayer made in the present writ petition, the petitioner's personal grievance on such score has also been ventilated, which renders the writ petition which gives the writ petition mixed color, both having ingredients of a public interest litigation and a personal grievance. Full stop. Insofar as the personal grievance is concerned, the respondent number 3 is directed to file a report as to the reason why the daily orders of the lower courts and tribunals are not being uploaded regularly. First up, a report in that regard shall be filed on the next returnable date, that is on August 17, 2023, when the matter shall be placed fairly at the top of the list. First up, a copy of this order be communicated internally to the registrar of this court by August 4, 2023 to ensure compliance.
By the department or by petitioner?
No, internally. Department.
Internally.
So another petition can be tagged with this. That can be.
Let us see the report in this writ petition.
That would be individual capacity. Lordship accept.
But Mr. Dotto, as far as I know, I'm not sure because of our court. I have a clue on this. Probably this is not from our end. It is probably uploaded every day.
No, I am not.
But no, not that. The NIC probably from the NIC end. I mean, for which this is happening. We suffer for this also because our orders are not uploaded. We put in certain directions to do it within 24. Our officers even stay back till 8 o'clock, 9 o'clock. Sometimes they stay back. Actually, they stay back. We also stay back so that this can be uploaded immediately.
Yes.
That is also done from our end. But often it happens the central network is not functioning.
That reason should be looked into. What is the actual reason?
But the High Court, whether the High Court can do it, I mean, maybe the registrar's report.
Supreme Court e-court service has been added in that particular writ petition. That in that Supreme Court.
That there will have a better remedy.
That writ petition could be taken.
Can you let that report come if they are, if it is indicated some other authority is responsible? I'll direct you to implicate them also in this matter. এটা ফেরত
17th is Sunday. 17th is Sunday.
না বৃহস্পতিবার মঙ্গলবার হচ্ছে স্বাধীনতা দিবস
17th বললো 17th বললো